matter for withdrawal. For withdrawal of 2016 petition, the only difficulty is that the well advocate on record is Sheila Prasad. I can get written instructions from the client for withdrawal, but there's no wakalat.
When you can get written instructions, you can file wakalat also. And then you mention it.
I will.
Petition matter from the list serial number 78. This matter has been fixed today by the judicial order passed by the coordinate bench. In this matter, the leadership has already decided the main matter relating to the maintainability of the complaint case under section 33A of IBI. That is in which the parties are also same and the counsels are also same. Mr. Rahul Kumar appears on behalf of the respondent government. I have informed him. I was just praying that if possible and the matter may be taken up to your
You have decided it.
Your leadership has already decided.
Which case?
This WPL number 2703 of 2018.
This order has been finality?
Yes, no LP has been preferred till today. Just in the morning I have checked on the website.
What is the date of the order, you remember? Only 2 months have expired. 2 months must have expired.
हाँ सातवां महीना नहीं हुआ है.
उनको बुलाइए लेकिन आज नहीं डिसाइड करेंगे, कल डिसाइड करेंगे. बिना पढ़े कोई केस डिसाइड.
So
We'll just find it out. Come at 2:50.
serial number 78.
Call him.
78. WPL 2123 of 2016.
From supplementary list for admission item 3, WPC 204 of 2019.
But petitioner has earlier approached this on the court. Past by this on the court.
Where is that order?
That order you received is Section 3, page 25.
Can you read it?
By this order,
Can you read this order?
yes. The writ petition has been filed for issuance of direction upon the respondent to particular the circle officer and involve respondent in the court to decide application filed by the petitioner for mutation of the land pertaining to CS plot number 416, Khata number 45, Moda Safarpur, district Dhambad, measuring an area of 10.63 acres to record the same in the register 2 under the provisions of the VR taking for the Records Act. When the counsel for the petitioner submit that in pursuit of the judgment and decree dated 30th January 2018, Honorable Supreme Court, Civil Judge, Civil Division, Human 5, Dhambad and Original Suit number 262 of 16, petitioner has
What happened thereafter?
before the
What happened thereafter?
Thereafter, despite this direction, the application has been rejected. That is at annexure 4/1, page 39.
Page number
Page 39.
39. Yes, please read it.
राजस्व कर्मचारी एवं अंचल शिक्षक से प्रतिवेदन के अनुसार आवेदक द्वारा भूमि सुधार के न्यायालय में दाखिल कार्यपत्र प्रस्तुत पर कागज के जांचों दौरान द्वारा गलत आधार पर प्राप्त किए गए निर्णय के वापसी 4/9/18 को विविध साक्ष्य संख्या दायर किया गया है, जिसका विचलन लंबित रहते याचिका की माननीय उच्च न्यायालय में याचिका दायर करके आदेश प्राप्त किया है तथा पुनः दिनांक घटना को भूमि बेदखल हो जाने तथा पुनः किसी अन्य व्यक्ति द्वारा भूमि का विवरण दखल किए जाने की जानकारी अनुमंडल पदाधिकारी को दिए जाने का पता अनुमंडल पदाधिकारी के पत्रांक संख्या इतना से पता चलता है तथा आवेदिका भूमि के संबंध को जमाबंदी नहीं रहने तथा तथ्य एवं पत्रकार नहीं रहने संबंधी आवेदिका के व्यक्ति के आरोप में दाखिल खारिज आवेदन को स्वीकार करने और से खारिज किया। Allotment, kindly see the direction passed by this court, that is para 6. Considering the aforesaid fact, petitioner is given liberty to file a fresh application before the respondent number 4, along with prescribed fee for the mutation in question on receipt of said application, The respondent number 4, after following the due procedure prescribed under 1973 and providing due opportunity of hearing to the concerned parties, without affording any opportunity to myself, this application was
Yes.
rejected.
Your Worship, this is the online rejection, Your Worship. They have filed in the online process. And there they.
Naturally, your online process, you have a system, they file it online process.
Yes, yes.
So,
So this was dismissed because there was the pendency of this one appeal, Your Worship, which is
What
mentioned,
appeal?
Your Worship. And there.
tell us what appeal. Yeah, I'm not able to even figure out the case number.
They have preferred
Vivid
civil-
Vaad Sankhya
civil
132
review. That has been dismissed. First appeal has also been dismissed. We have dropped all
I
the
agree.
documents on it.
I agree. I'm coming to that. Your Worship. All have been dismissed, Your Worship. Now the state has preferred a second appeal, Your Worship, which is pending.
We are
Which
not
I
bothered
agree.
about it. You grant them hearing in passing.
Yes.
There is an order in their favor.
Yes.
Once the state, your second appeal must be defective. आपका तो
No,
defective का
defect
कहानी
has been
चलता है.
removed on 7/9/2024.
So now there is a judgment in their favor. You do the needful. आप जीत जाइएगा तो अपना mutation कर लीजिए.
I also agree. That has to be done. लेकिन ये they have filed one supplementary affidavit in this case that they have moved another fresh mutation application. So that may be disposed of in that way. कि fresh mutation.
नहीं fresh नहीं इसी को इसको set aside करेंगे.
क्योंकि supplementary में ये ले.
No no.
ठीक
इसको
है.
set aside करेंगे.
Set aside करके उसको फिर से मानना.
Yes. You want this only? Why have you moved fresh application?
They have filed. Client has filed. No, not to have.
उसको डिमांड बैक करके वहाँ डिसाइड सुनवाई करके डिसाइड.
देखिए सर. WPC number 204 of 2019. Heard the learned counsel for the parties. This petition has been filed for the following relief. The learned counsel for the petitioner submits that the petitioner had filed original suit number 262 of 2016.
Degree is at page 16. Details of landing at page 26 in the schedule.
And submits that the right, title, interest and possession of the petitioner was confirmed in the title suit, and the state of Jharkhand was a party. The state of Jharkhand and its other authorities were party in the state proceedings. He submits that the petitioner had filed an application for mutation
That is the
And-
constitution.
and when no order was passed, a writ petition was filed being WPC number 4697 of 2018, wherein this fact has been observed, seeking a direction upon the respondents, particularly the Circle Office of Dhanbad, to decide the application filed by the petitioner for mutation of land involved in the present case. The learned counsel has referred to the said order dated 17/9/2018, passed in WPC number 4697 of 2018, and submits that a specific that this court gave liberty to the petitioner to file fresh application before the respondent number 4 with prescribed fees for mutation of the land in question. And it was directed that on receipt of the said application, the respondent number 4, after following the due procedure prescribed under the Act of 1973 and providing due opportunity of hearing to the concerned parties, shall pass appropriate order in accordance with law within a period of 12 weeks. The learned counsel submits that the order of this court was brought to the notice of the Circle Officer Dhanbad by the Annexure 4 and by the Annexure 4, but in spite of that, on 31st of December 2018, the petition seeking mutation has been rejected without giving any opportunity of hearing to the petitioner. He has submitted that the direction of this court has been clouded and the decree clearly indicated possession in favor of the petitioner. He has submitted that a finding was also recorded in the trial court that the petitioner was in peaceful possession of it. है ना finding?
Finding.
यहाँ पे तो है. Learned ASO deputed a survey for physical verification of the suit land, who conducted a survey of the suit land and found that the plaintiff is in possession of the suit land and as such submitted the report.
पोजीशन पे डिस्प्यूट करेंगे ये लोग समझ लीजिए इसको ना लिखा जाए क्योंकि एग्जीक्यूशन से
भाई
फाइल
इसमें जो है सो है we do
they
not.
have filed for execution of the taking of possessions. That's why
You are filed in the execution.
execution case of 21 of is that's why this should not be mentioned.
No, some
Execution is
So
fine.
you see, this is there in the judgment.
It
We will
is
not-
there in the
We will
judgment,
not
but-
say anything more,
Yes,
right?
it is there, Your Lordship, but why they have
No,
filed
it is
the
there. We do not know. It is there. वो क्या किए हैं बाद में डिस्पोजल्स हुए होंगे. आप लोग तो माइट ही है ना, माइट आपके पास.
ये फाइल किए थे review application. That was
Anyways.
dismissed. Appeal was dismissed. Thereafter, some encroachers might have filed some order
Okay,
21,
we are not
97
concerned about
petition.
that. We are concerned
नया
about
dispute create हो गया.
the learned counsel submits that the writ petition be disposed of on the short point that no opportunity of hearing was given to the petitioner in spite of clear direction by this court by the order dated 17/9/2018 passed in WPC number 4697 of 2018. The learned counsel appearing on behalf of the state has submitted that the matter may be remanded to the respondent number 4 for passing fresh order after giving an opportunity of hearing to the concerned parties, including the petitioner. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that the petitioner had filed an application for mutation by virtue of a decree passed in title suit declaring right title interest and possession in favor of the petitioner, in which the state was the defendant. When the application for mutation was not processed, writ petition was filed seeking a direction upon respondent number 4 to pass appropriate order. This court, by the order dated 17/9/2018, disposed of the writ petition with considering the fact that suit has been decreed in favor of the petitioner. The operative portion of the order is at paragraph 6, which is quoted as under. The impugned order as contained in Annexure 4 by 1 communicated to the petitioner through online process. This is online.
This now it is online.
ये ऑनलाइन मिला
ये भी तो online.
ये ऑनलाइन ही मिला
Through online process has been rejected without granting any opportunity of hearing to the concerned parties, including the petitioner. In such circumstances, this court is of the considered view that the direction contained in WPC number 4697 of 2018 has not been followed by the respondent court. Consequently, the improved order dated 31st of December 2018 as contained in Annexure 4 by 1 cannot be sustained in the eyes of law. And the same is hereby set aside. The matter is remitted back to the respondent number 4 for passing fresh order in accordance with law, taking into consideration the direction passed by this court in WPC number 4697 of 2018. The petitioner to appear before the respondent number 4 on 11th November. On 11th November, and upon his appearance,
after November में भी done है so because election date has been declared on 13th तो सब
इसको
दिक्कत
पहले डिसाइड करा, इसको पहले डिसाइड करा.
इनको अपॉर्चुनिटी देना अगर उस डेट पे आएंगे तो वो उस दिन रहेंगे कि नहीं क्योंकि सबको तो ड्यूटी मिल जाती है दैट्स व्हाई आई एम सेइंग
इलेक्शन तो 14-15 को,
नवंबर में तो खत्म ही हो जा रहा है दिसंबर में डेट दे
18 तक तो सारा इलेक्शन खत्म हो
हाँ
गया.
23rd को रिजल्ट डिक्लेरेशन उसके बाद के कोई डेट दे दे तो उसमें कर लेंगे
23rd को रिजल्ट डिक्लेरेशन, 26 तारीख. On 26th of November 2024, along with a copy of this order and the records of this case, fresh order be passed by respondent number 4 after granting an opportunity of hearing to the concerned parties without being influenced by any observation made in the improved order dated 31/12/2018.
Yesterday, my lord, I had
Just a moment, just a moment. That's all.
Yesterday, my lord, I was examining law on this issue, that whether a decree passed by the civil court is binding on revenue authorities or not. I find several judgments of other high courts. In our high court also, the Honorable Justice Anand Tiwari had passed one judgment I remember. It is reported that it is binding.
The provision is very clear. Once the decree is passed, it has to be communicated to the circle officer for the purposes of mutation. No application for mutation is
Yes.
required to be made.
Yes.
हमको तो कॉस्ट इम्पोज
Yes.
करने का मन
Yes.
कर रहा है, लेकिन जाने दीजिए, उनको टैक्स मत करिएगा, बोल दीजिएगा सर्कल ऑफिसर. लगता है कुछ ठीक से हुआ नहीं, इसीलिए सब ऑर्डर हुआ.
कितना सर्कल हो सकता
It was a case for imposition of cost, isn't it?
है
Needful be done within a period of 1 month from 26th of November 28.
Yes, sir.
The order be communicated to the petitioner through speed post.
Item 4.
Petitioner and the concerned parties, everybody.
Item 4. WBC 1196 of 2019.
Yes, petitioner.
Before the writ is argued, I have an preliminary objection with respect to maintainability of the writ petition.
Which order has been challenged?
The order at Annexure 10, page 71. This is an order passed in pursuant to an order passed by this Honorable Court.
What is your, where is the earlier order passed by this
Yes.
court?
The earlier order is at Annexure 7 at page 42.
Did you deposit 75%?
Yes, has been deposited.
No, Your Lordship. That has not been deposited. Why I am saying so? Because in the earlier round of litigation, they have deposited the 75% of the then amount, interest amount. However, at present, when the writ was filed in the year 2019, the amount has cropped up to 23 lakh rupees, which they have not deposited. Only the earlier amount which they are claiming to be deposited.
Let us see, let us see. Just
Yes.
we will see that what is the scope of this.
Yes,
litigation.
only that much. On remand, what they have taken. Now kindly see Annexure 7 at page 42. A proceeding was initiated under the MSMED Act for an amount of 50,000. Now the matter was taken up and finally an order was passed against us without hearing us. Now against that we filed a writ petition. Now kindly turn to page 49. It's a long order. The earlier order is quoted at page 49. Then your Lordship would kindly see the directions that have been passed. So the order is quoted in highlighted in the order sheet. Then I'll read the next paragraph. It would be repetition to say that Facilitation Council had to satisfy itself in the necessary ingredients of the provisions of section 15 and 16 etc. and render its finding on each of such claim arising out of such supply orders, such as the date of supply order, the date on which the supplies were made, the date on which bills were raised, the date on which the acceptance of supplies were made or refused. In the facts of the case of the applicant, it was required to render a finding as to form which date the liability of the buyer arose to make payment of outstanding dues. The payment would then become due from those dates against the buyer in favor of supplier. The liability of the buyer to pay interest over the original amount would then accrue from the date as adjudicated
What
by.
the authority has done?
Yes, kindly come to page number 72. It starts from 70, that is Annexure 10. And the award is at page 72. Paragraph 3. The opposite party did not attend the 6th number of council meetings held in so and so as detailed at point number 2, which shows that the opposite party has nothing to say in the defense. In compliance of the Honorable High Court's order, sufficient apology was given to the opposite party, but opposite party did not respond, and as such there is no need for any interference in the order. No decision in terms of the remand order passed by the court. And we have said that the notices that were sent to some other place, but leaving aside that, the order of remand passed by this Honorable Court has not at all been complied with. Straight away, there is no reason to interfere. And the order that has been passed earlier, as I had shown to your Lordship, kindly come to page 49 once again. What was the order passed? This is page 49 that has been quoted. In the middle paragraph, number 2, the
Under
opposite.
the provisions of Arbitration and Conciliation Act 1996, in case of non-compliance of principles of natural justice also, that is one of the grounds for trial. We will
No.
not entertain the writ.
No, what I submit is, now here is a case where a specific direction is passed by
It
this
is
court.
not a case that it is the award is without jurisdiction.
No, I say it is. I say that it is without jurisdiction.
No, it cannot be said to be without jurisdiction.
No, I say my submission is that in terms of the order passed by this court,
Right?
the council was required to pass orders considering these facts. What was there? The claim that was
See,
filed.
that is on the merits.
No,
that
I'm
they have
not touching-
violated the orders of this court. The notices were not served on you. These are all on merits. Which
No,
you
no,
have
on
to
merits
satisfy
I say.
yourself.
On merits, I would say,
You just show the law on this. 34 is the only remedy because 34 under 34 one of the grounds is violation of natural justice.
no, that was there earlier also. We filed a
See,
petition.
That's right. We do not know. This,
Yes,
this order has attained finality. We have nothing to say.
No, kindly
Right.
see that earlier order.
We have seen that once the writ petition was entertained, nobody has challenged it. The matter has been remanded. Now we are not inclined to entertain.
No, same, on remand they have not done anything excepting that it does not require any interference. Nothing else. Nothing else. Not a single word added here or there. The order passed earlier does not warrant any interference. That is all. Because of the fact that this court has passed an order on remand under Order 41 Rule 33, they were required to consider all these aspects.
So they have violated the court's order.
Yes,
You go under 34.
no, 34 is not the remediable.
Otherwise also, even before this court, you have to deposit 75% of the entire amount.
No, I have deposited earlier.
No, that was returned back to you.
No, it has not been returned.
But
They have filed an application for withdrawal of that amount.
who has filed an
I filed it stating that although I am in need, it's an SSI unit, I am in need of money. Although I have stated in my IA that amount does not form 75% of the total disputed amount. That I have not even pressed.
There is a legal bar. We really can't.
Lalas, I would submit that
Even
even in points relating to alternative remedy, there are a number of judgments which have said that in cases where there is violation of principles of natural justice, this court would interfere. That is the reason why they at the first instance, this court
Not
had
in
interfered.
arbitral proceedings.
No, in the first round, it was an
Not in
arising out of
arbitral
that proceeding.
proceedings.
Kindly say Annexure 7.
Not in arbitral.
It arose out of the same order.
there is one judgment of your ladyship itself, your lordship, wherein your ladyship has dealt in detail with this aspect of the matter.
No, I had nothing to say. Otherwise, had this order not been there in the writ petition, I would have not come to this court. Since the writ petition was entertained, the court passed an order that you consider all these aspects of the matter. But none of the points have been considered. Straight away they say, this is the order. There is no point of interference.
Those pleas can be raised before the appropriate forum under section 34 of the Arbitration
This
Act.
was also the
That is all
objection
about
at the
the
first
facts.
round.
That is all about the fact.
Merely
Those pleas
because
can
one
always
writ
be
petition has
raised.
been entertained, that doesn't mean that we are going to entertain writ petition.
No, I
after
would
it.
submit my submission.
You satisfy this court that this writ petition is maintainable irrespective of section 34.
Yes.
Only on natural justice because 34, one of the grounds is natural justice also. That is available under section 34.
No, I
And
would-
otherwise also there are judgments of the Honorable Supreme Court that 75% of the decretal amount has to be deposited.
the
How much
decretal-
is the amount?
50,000 is the amount.
50,000 plus interest. How much is the amount?
We deposited a sum of rupees 3 lakhs.
That is not sufficient. You showed me the calculation that you have, that as of now 75% of the entire amount is before the court. There was a direction to return the amount to the petitioner. Why
Yes.
didn't you take that amount?
No, I did not take that amount. That amount is lying here. They filed an application here.
That's right. This order was passed on 14/9/2016 with a direction to refund you the amount. You did not take any step.
No, the amount is lying here. There is no doubt
It
about
will
it.
keep lying here. You don't bother since 2016 the amount is lying over here.
No, I would submit. My submission before Lordship is that on remand, the council was required to consider the directions passed by this court. The council has noticed the order passed by this court, but has in one line said there is no scope for interference.
Because you did not appear.
No, the reasons I have submitted. We did not appear.
Even
Still, they were required to establish the claim. Now let us see what the claim was.
They have given entire calculation, everything is there.
No, that
Interest
calculation.
certificate is also there of the chartered accountant.
Well, it's a
Which
two-line
is an
order.
undisputed,
No, it is a disputed amount.
from who has disputed
No,
it?
we have disputed it
Where is the dispute?
in the written statement. That is
Show
all
me
my
your
submissions are. Mallards.
Show me your
We
written
dis-
statement. Where is
we-
it?
Yes.
If the High Court order, if seen, there is an RTI by them in the High Court order. It is recorded that they have admitted this amount. That is there in the High Court earlier order itself, Your Lordship, page 44.
Had it been an admission, then there would have been no occasion to remit the matter.
So that is why I want to see your written statement.
Yes, kindly see. Page 33.
Where is that judgment? I have forgotten arbitration by now.
Yes, Your Lordship, that the judgment passed by in the division bench. And also the Supreme Court judgment is there on the same line, Your Lordship, which is this is the recent judgment of the Honorable Supreme Court. The relevant para of that judgment is just quoting para 53, 54. 53, Your Lordship, it starts from 53 to 55, it runs from. May I read those paragraphs?
Just a minute. And when did you file this writ petition?
That is also with delay after passing of 3 months plus.
Oh, yes, because we did not receive a notice of this proceedings.
No, when did you? What is the date of communication? Where is it? Where have you mentioned? What is the date of communication of the impugned order? If it has become barred by law, if your 34 has become barred by law, writ petition otherwise also will not be entertained.
Paragraph 24.
This is order dated 5/4/2018, right? When did you file it? 5/3/2019.
Yes,
When did you receive the award?
kindly see the notes. I have stated from paragraph 24 onwards, page 20.
You just give me one date. When did you receive the award?
Can I
I
state that?
I received it on
Para 25, they have stated that through my legal notice, that is on 12/11/2018, they received that award. They applied for the certified copy thereafter. Para 25 of the writ petition, page 21. Whereas as per me, they have received the award on 19/9/2018. That is also annexed with their writ petition. Page 57 is my first first notice which I gave them, annexing therewith the impugned judgment or award.
I have received it on 10th of January 2019 and I have filed the petition on 5/3/19.
You can file, you can apply at any time you want to, but at least you had knowledge on 12/11/2018.
Yes, you have stated so. And my contention is only one, that on remand the principles of Order 41, Rule 23, 23 and 25 have to be complied with. And the specific direction is that he or she has to
On
establish.
remand order, on
On
remand which order was to be followed?
Order 41 Rule 23 and 25
What does that provide?
provides
Do you want to say that a copy of the award was never served on you because there is a direction to issue the award to you?
yes, it was never served upon us.
Where do you see?
Order 41 Rule 23 provides that remand of a case by appeal, but the court from whose decree or appeal is preferred has disposed of the suit upon preliminary point, and the decree is reversed in appeal. The appellate court may, as it thinks fit, by order remand the case, and may further direct what issues or issues shall be tried in the case so remanded, and shall send a copy of its judgment and order to the court from whose decree the appeal is preferred, which directions to readmit the suit under its original number and register civil suits and proceed to determine the suit, and the evidence, if any, recorded during the original suit shall subject to all just expositions be evidence during trial and remand. Then 25. Where appellate court may frame issues and refer them to trial to the court where decree appealed from, where the court from whose decree the appeal is preferred has omitted to frame or try any issue or to determine any question of fact which appears to the appellate court essential to the right decision of the suit upon merits, the appellate court may, if necessary, frame issues and refer the same for trial to the court from whose decree the appeal is preferred. So this is what I submit. This court framed issues. You decide these issues. 1, 2, 3, 4. None of the issues have been even touched. This is my submission. This court holds it was required to render a finding as to from which date the liability of the buyer arose to make payment of outstanding dues. The payments would then become due from those dates against the buyer in favor of the supplier. The liability of the buyer to pay interest over the original amount would then accrue from the date as adjudicated by the facilitation council. So none of these, and before that, why the court has said this order is illegal, it holds that they were required to record a finding on each of such claim arising out of such supply order, such as the date of supply orders, the date on which the supplies were paid, the date on which bills were raised, the date on which acceptance of supplies were made or refused, or nothing has been done. What they have done is passed one line order that this is the amount that is found payable because you have not appeared and contested the matter. Straight away. They should, even if I do not file a written statement, still the court is bound to consider the claim set up in the plaint and decides on its merit based on evidences. So only this is my submission before your lordship, that on the grounds of natural justice, because duty is cast upon the authority to assign reasons. Quasi-judicial authority, having not assigned any reason whatsoever, the order is bad on account of principles of natural justice. Kranti Associates has already dealt with these matters. One single reason they should have assigned, that this is the reason why this has to be allowed in the light of the High Court's order. High Court's order is noticed.
Where is Kranti Associates?
Kranti Associates is
हर एक केस का ना अपडेट देख
नहीं।
लिया करो।
हाँ,
कोई भी केस, particularly when it comes to arbitration,
no, I'm
law is still fluid in many aspects of it.
I'm submitting.
Where is Kranti Associates?
Kranti Associates is reported in 2010, 9 SCC
Where is
496.
it? Where is it? 2010. उसके
2010,
बाद तो much water has flown.
9 SCC, 496, para is 47.
What does it say?
Sorry, I have not provided your lordship. Summarizing the above discussions this court holds, in India, the judicial trend has always been to record reasons, even in administrative decisions, if such decisions affect anyone prejudicially.
You see, these.
Judicial
Have you
authorities.
raised any point which is not amenable to Section 34?
Yes, I have not taken that point because I have said that
And
this order is
you
in
need to
violation.
satisfy on 2 points. One is whether any of the points which you have taken is not covered by Section 34. One thing. Because in the case of what's the name of that JSAB from state of Jharkhand, state of Rajasthan.
Was the first and
Jharkhand
foremost.
Urja Vikas.
And that is quoted in that judgment itself. Your
Was the
lordship has
first
taken
and
note in that
foremost.
judgment.
Now under the Arbitration and Conciliation Act 1996, unless the award has to be a speaking and a reasoned order.
So therefore, it is one of the grounds under Section 34. And second point which you need to satisfy us is the limitation. If challenge to an award is barred by virtue of any law under Section 34, will the writ court entertain and decide the case on merits?
Well, as a writ court, I have tried to explain the sequence of events that I could not appear before the authority because notice was sent to some other.
This is on the merits.
All right, this is on merits. The moment I received it, I
You
took
have not
steps.
stated that the order which was directed to be issued, in the order itself it is mentioned that serve copies to the parties. It is mentioned. And you have not received the award directly from the Facilitation Council. It is not mentioned in your declaration.
That is true. I have
Therefore,
said so.
date of knowledge or date of receipt or not non-receipt, this is absolutely an essential fact which triggers the point of limitation under Section 34. There is no such statement. How do we know whether 34 was barred, not barred?
No,
One can file an application at any point of time.
No, what I submit before Lordship is that because on the earlier occasion, this court passed an order of remand and the remand order is very specific and no reason have been assigned, nothing. It has not even touched the order of remand.
I fully appreciate.
But still,
But the point is that this is on merit. And I am on my jurisdiction under 226. So unless that gate pass is available to you, we will not enter into the merits of this.
my submission therefore, again I have no other submission excepting that. That is the prayer in the writ petition also. And this is the prayer before Lordship once again. That there is an order of this court and this court having passed that order, the principles of natural justice have been violated inasmuch as no reasons have been assigned. And that is the reason why I am here. Otherwise the order of this court is meaningless. This quarter passes.
This judgment has attained finality.
Yes.
Yes.
No, this judgment, Union of India, LPS 644 of 2010.
Yeah,
The-
I had checked this, but
I'm telling,
yes,
I keep track
checked
of my
this.
judgments because if I take a view in a particular case, I take strong views, right? Either ways. If I take a view in a particular case, then if that view is overturned, then I have to change my views. So I keep a track, particularly in arbitration, I keep a track.
I had also checked in the website. I could not
As
find
I
it.
remember, this judgment has been upheld. But please check it also.
Gee,
this Kranti Associates Constitution Act 1996, there is a requirement to pass a reasoned award. Okay, you file your whatever submissions you wanted. You cite your judgments also. I'll take care of all the judgments. I've heard you enough. Right?
So only 2-3 points, Your Lordship. So far as
On the
principle,
point of maintainability, you file. And then if I'm satisfied with the maintainability, I'll go into the merits of the bill. Anything else you want to say on
I
merits?
just the ground for challenging the award before this honorable court, one is
See,
that
as I see, their only ground is that the order of this court has not been complied with. Right?
and they are saying that notices were not served on the address because there was a change of address. That is also not a correct fact. It is evident from the record itself, Your Lordship. From the award itself may kindly be seen. And the
That will be entering into the merits.
and my also
If I
ground is
decide the case on maintainability, then I will not enter into the merits.
as already shown. And also my ground is then my only ground is that the writ is also filed after a delay of 3 months plus 30 days, Your Lordship. Why I am stating so? Because Your Ladyship can see page 57 itself. The award is of 20. Award is of. It is of 5th of May 2018, whereas it was filed on 5th of March 2019. That is 1 month delay. Even if a year delay, even if they are saying that they were not aware of the award was made them aware way back in September 2018. That is evident from their writ petition itself, page 57. Page 57 may kindly be seen. Wherein through my letter I have duly sent them. Apart from that, the MSME Council have sent that. I have also personally taken care of sending them the award. Page 57.
This is annexure number.
This is part of the annexure. Part of annexure 9.
Another notice dated 19/9/2018.
2018. And in this I have annexed that they have itself brought this letter in their writ petition, annexing that order that can be seen from page 61. I have annexed both the order of the learned forum, the earlier order as well as the present order, which is the impugned one, page 61 enclosure, and I have also stated in detail about the said order. So that they were in knowledge since 19/9/2018 at least. They applied for the very first time for the certified copy after.
There is no mention of receipt of this particular notice dated 19/9/2018.
Should they
They have
themselves
simply
have
annexed it.
Yes, they have annexed it. They were in receipt, therefore they have annexed it. It is there in their record. I have not brought this document. It is their document which they are bringing on record, and it was sent to the address which they have mentioned in the writ petition that the notices should be sent on these addresses, and these notices were sent on the said address itself. Para 24 of the writ petition, wherein they have stated that notices now henceforth be required to be sent to the Koila Bhavan, Koila Nagar, Dhanbad, and this notices has been sent. It is their record which they are bringing on record this particular notices.
The service of notices as well as the service of the award requires evidence. The service of the notices issued by the facilitating council as well as the service of the final award both requires identification.
This is my contention is because why I am saying so again, Your Lordship, from the impugned award, if it may kindly be seen, page 64. That was also forwarded to them to their proper address, page 64. First, Your Ladyship may kindly turn to para 24 of the writ petition, wherein they are stating that page 20 of the writ petition, para 24. May I read it? Para 24, that the petitioner state that upon remand of case number so and so to facilitation council, the petitioner was expecting that notice of hearing of the said case would be served in the office of the general manager PB area BCCL. However, no notice of any hearing in connection with the case number was served in any of the functional office, including the BCCL headquarters, Koyla Bhavan, Dhanbad. So these are the two addresses which they are mentioning it. The notices, all the notices, page 62 is the impugned judgment which start from. It states that the party position is there, CK Industries so and so versus BCCL, Koyla Bhavan, Koyla Nagar, Sarandi, Dhanbad, and then again it was sent to copy to, that is page 64, may kindly be seen. Page 64, it is written copy to my address, CK Industries, Katras Road, so and so, and Bharat Coking Coal Limited, Koyla Bhavan, Koyla Nagar, Saradi, Dhanbad for information and necessary action. So this is the particular address which they in their writ petition itself is mentioning that the notices need to be served on this particular address, and accordingly it was served on this particular address itself. However, they chose not to appear before the forum, neither any writ was filed. We took the initiative of serving that notices by a legal notice dated 19/9/2018, which is again contained in their writ petition, page 57 itself, wherein I have brought to their knowledge that, see, this is the order which has been passed, and since then they were in the knowledge, they applied for the certified copy first on 13th of December 2018, that is after a delay of more than 2 months from the date of communication from my side. On 13/12/2018, they have applied, which is also evident from the writ petition, page 22.
In one judgment, I have decided that if the 34 application becomes time barred,
That is there in this particular
Yes.
order. Yes.
Where
Page
is it?
para 53 of latest.
yes, just like that.
Para 53, that is page number is not mentioned there, Your Worship. It's third last page.
Yes.
This court is of the considered view that merely because the LPA court had given liberty to file the petition under section 34 of the Arbitration Act, the same by itself cannot be taken to have given an extended period of limitation to challenge the award beyond what has been prescribed under section 34(3) of the Arbitration Act. It is not in dispute that on the day when the first writ petition, being WPC number 6876 of 2012, was filed challenging the award, the remedy under section 34 was already barred by limitation, and clear finding to this effect was recorded in the order dismissing the writ petition, being WPC number so and so. In such circumstances, the appellant cannot even take any advantage of section 14 of the Limitation Act 1963 for exclusion of the period spent in pursuing the litigation against the arbitral award in the High Court. Such course of action, as argued by the appellant, would be in direct conflict with the judgment passed in the case of Simplest Infrastructure Limited versus Union of India Supra, wherein it has been held in paragraph 18 that a plain reading of subsection 3, along with the proviso to section 34 of the 1996 Act, shows that the application for setting aside the award on the ground mentioned in section 34(2) could be made within 3 months, and the period can only be extended for a further period of 30 days on showing sufficient cause and not thereafter. It was found in the said case that even if the benefit of section 14 of the Limitation Act was given to the petitioner, remained barred by limitation, which was beyond the strict timeline prescribed in subsection 3, read along with proviso to section 34 of the 1996 Act. Paragraph 18 of the said judgment is quoted herein as below. Then para 54, should I read the quoting?
No, it's line number. इसका जरा status देखिए तो इसका ऐसे LPA number 644 of 2022. 16th August 23 को decide. You filed your written submissions. I've heard you. You filed your written submissions. The judgments which you cite, please check the up-to-date status of those judgments. 2010 ka judgment, we do not know what ultimately. There has been subsequent consideration of this Kranti SOPs, but I do not know what ultimately happened.
Also, the judgment one which I have passed
Yes.
on just now, that is of Supreme Court judgment, India Glycon. In this also, the Honorable Supreme Court has said that if there is a remedy under Section 34, it should not be entertained, be it the ground of limitation, natural justice, and also 75% deposit is mandatory. Even in this judgment, the court has not granted liberty to file an application under Section 34 only for the reason that they have chosen wrong forum. That is para 16 of the said judgment.
You prepare your note, both of you give soft copies to us. Because your submissions are required to be recorded fully. I do not know whether you have become remediless. I do not know whether you have now become remediless.
No, I do not know. These are my submissions. It is nothing, everything has been brought to your Lordship's notice. All the communications that
See,
have been
whenever
made.
we entertain a writ petition in these kind of matters, we are conscious of the fact that these are the judgments which will create a precedent. It has a precedence value. So we have to be very careful while entertaining a writ petition and a Supreme Court.
Since at the first instance this court interfered in the matter, set aside the award, past directions to be complied with, nothing being done, that is the solitary point. Nothing
That's
else.
right. You kindly highlight your point and file your written submissions. Who's for the
That
state?
has been challenged in the Supreme Court and it has also been disposed of. I'm just getting the judgment.
Which was challenged?
That judgment of your ladyship, which I just referred, it has been disposed on 1st of December 2012. I need to see that whether this is same, but the party position is
110/2000?
It was disposed of on 1/12/2023. The SLP number is 027886 of 2023.
I think
027
some certain
886.
points have been kept open. I कुछ ऐसा इस तरह का observation.
मैं अभी order देख लेती हूँ.
इसका order नहीं करना. हमारे कोर्ट मास्टर को मेल कर दीजिए. हाँ जी. मेल कर निकाल लीजिए प्रिंट डिटेल्स.
No, Your Lordship, it is just we are not inclined to interfere with the impugned judgment and order passed by the High Court. Hence, the special leave petition is dismissed. Only this is the order. I will be giving the SLP number.
We are just taking out. ठीक है? WPC number 1196 of 2019. Heard the learned counsel for the parties at length. Specific point has been raised by the learned counsel appearing on behalf of private party that the present petition is not maintainable. And she has also raised a point regarding non-deposit of 75% as per the provisions of Micro, Small and Medium Enterprises Development Act 2006. She has also submitted that the writ petition has been filed on a date by which the remedy under section 34 had become penal. The learned counsel appearing on behalf of the petitioner has submitted that the writ petition is maintainable in view of the fact that the order passed by this court has not been complied. He has submitted that the earlier award was set aside by this court and the matter was remanded. But the provisions, but on remand, the provisions of Order 41, Rules 23 and 25 of the CPC have not been followed. He has also submitted that there has been gross violation of principles of natural justice, inasmuch as the impugned award reflects that 6 notices were issued to the petitioner, but the petitioner did not attend the proceedings. He submits that he has made specific averments in the writ petition that the notices were not served, and therefore there has been a gross violation of principles of natural justice. He has also submitted that irrespective of the fact as to whether the petitioner appeared or not appeared, the direction passed by this court on remand was required to be followed in letter and spirit. The same having not been done, the impugned award cannot be sustained in the eyes of law and calls for interference under Article 226 of the Constitution of India. He has also submitted that merely because the petitioner had a remedy under Section 34 of the Arbitration and Conciliation Act 1996, the same will not outstate the jurisdiction of this court under 226 of the Constitution of India. During the course of hearing and upon going through the records of this case, the learned counsel for the petitioner has not been able to show any averment in the petition with regard to non-service of the order of the award, which was said to be communicated to the parties as is reflecting from the impugned award itself. It is further not clear from the records as to the date on which the award came to the knowledge of the petitioner for the first time. However, the petitioner has also annexed a copy of the notice dated 19/9/2018, which is a communication from the private respondent to the petitioner. The date of receipt of the said notice has also not been mentioned in the petition. The learned counsels have also submitted that they would be citing certain judgments in support of their respective contentions, and liberty may be reserved with them to file a written submissions, file their respective written submissions. The hearing of the parties is concluded. It is open to the counsels are directed to submit their written submissions within a period of 1 week from today with their synopsis of arguments and the judgments which they seek to rely upon. It is expected that the judgments which they cite, while citing a judgment, they will take care regarding they will take care as to whether those judgments still hold field in view of the fact that there have been numerous judgments by the Honorable Supreme Court under the Arbitration and Conciliation Act 1996 from time to time. Take it.
Is
Order
submitting the
reserved.
written submission online or the hard copy?
I need both. I don't want to burden my stenographers unnecessarily. These judgments, whatever you have cited, please annex it again with your written submissions.
Absolutely.
And both of you exchange amongst yourselves.
So,
Whatever, you can exchange soft copy, hard copy, whatever.
Hearing item 5, WPS 452 of 2006.
Yes.
Annexure 5, that is the award that has been passed in reference case number 125 of 1996 is under challenge. It starts from page 48. Government of India Ministry of Labour in exercise of power conferred under section 10(1)(d) of the ID Act 19.
Before you read the award, what are your main points, and then you will see.
Lordship, initially, Your Lordship, there was, in this case, Your Lordship, the concerned workman is Mr. J.P. Singh Hania. For the charges of embezzlement, Your Lordship, an FIR was drawn and there was a domestic inquiry. In the domestic inquiry, he was dismissed from service on 3/8/1982. Thereafter, Your Lordship, in the criminal case, he was exonerated. He was acquitted, Your Lordship, by judgment dated 20th of February 1984.
My judgment dated
22/1984. Thereafter, he filed one reference case number 310 of 1986 through an union.
what was
During
the
the
terms of
pendency,
reference?
yes, I am coming to the reference, Your
Okay,
Lordship.
reference case 1986.
Yes, 1986.
Then
During the pendency of the reference, this J.P. Singh Hania, the employee, died, Your Lordship, on the year on 13/4/1990.
13/4/1990.
Yes.
Died.
And the widow, Urmila Devi, she was substituted, Your Lordship. And thereafter, the award is passed on 27/2/1992.
27/2/1992.
92. Lordship, may kindly come to first.
What happened to that award?
In the said award, it was stated that he was wrong. The charges of embezzlement was not proved, and there was a direction that if he would have been alive, he would have been reinstated.
So some relief was granted.
Relief was
This
granted.
attained finality.
Yes, it attained the finality to the sense, Your Lordship, that the amount that was required to be paid, that was paid. That is not in dispute. There was a direction for payment of wages from the date of dismissal till the date of death. That amount has been paid to Urmila Devi.
The amount has been paid. What
Yes, that
further
has been
direction
paid.
was passed?
Beyond the reference, there was a direction for considering compassionate appointment for son of the Urmila Devi, of J.P. Singh Hania. Since it was beyond reference, therefore we wanted to challenge it before the High Court. The Urmila Devi and two sons approached the management, the general management Mugma area, and stated that we want to settle the dispute. You please make the payment. We don't want to press the relief claim with respect to compassionate appointment. That is Annexure 2.
Then what happened? Then what happened?
Thereafter, they filed another reference case, that is 125 of 1996.
No, just a moment.
Yes,
Annexure 2
is the settlement. Annexure 1 is the award. First award,
Okay. Annexure 2 is settlement. What is
Settlement.
the terms of settlement?
this settlement is dated
And what is the
28
date of
to-
settlement?
Settlement, may I read the settlement?
Yes.
Page 35.
Yes.
Brief history of the case. Late J.P. Singh Hania, while working as assistant cashier in Shampur Colliery, was dismissed from service with effect from 2/8/1982 on account of misconduct.
Yes, I have seen.
Yes.
Page number 36, there is a settlement. between
There
the
is a
parties.
settlement.
Thereafter what happened?
Terms of conduct of the settlement, that is important, page 36, may kindly be gone through.
Yes, I have seen that.
They say that they are not, they requested the management that you do not file any writ petition and we are not going to press for employment.
And the legal years, wives, etc. Everybody were part.
Everybody was party. The two sons and Urmila Devi.
Then what
Urmila
happened?
Devi, Anand Kumar Singhania and Arun Kumar Singhania and the representative of the union were witness to this settlement.
Okay. This attained finality.
This attained the finality. Thereafter, they filed one reference case number 125 of 1996, suppressing the fact.
This settlement is dated?
This settlement is dated 28th of February 1996.
20, 20.
28, 28.
20 to 1996. Okay.
And thereafter, Your Lordship, one reference
A reference was made
made.
on 14/10/19.
Yes.
This
The-
particular settlement
Yes.
was brought to the notice of the
Not by
tribunal.
them, it was brought to, they suppressed this fact, we brought it
Okay.
to the
And
notice
where
of
is
them.
the consideration of this settlement?
Yes.
Show me the consideration
Page
of
51.
Yes.
Page 50. They submitted that this tribunal on 27 to 1992 passed an award in reference case number 310 of 1986 in favor of the deceased workman. Thereafter, the said award was replaced by a settlement dated 28th of February 1996, and the aforesaid award got automatically terminated as per the provision of section 19 of the ID Act 1947. They submitted that the award remaining valid for a period of 1 year and it continues to remain valid till the same is replaced by another award or settlement. The award may be terminated after expiry of 1 year in accordance with the provisions of section 19 of the ID Act 1947. They submitted that the tribunal, going beyond the terms of reference, not only passed the award but also directed the management to provide employment to the dependent son of late J.P. Singhania as per the rules and procedures. They disclose that no right can be conferred on an employee in a public sector undertaking to provide employment to his son and relative after his retirement or death. Such employment can only be given on compassionate ground, considering all material placed before the management. They disclose that the award of Honorable Tribunal was not implemented by the management so far as providing employment to the son of J.P. Singhania was concerned. The matter was discussed between the legal heirs of J.P. Singhania at the instance of the sponsoring union, and ultimately the settlement was arrived on 28th of February 1996. They submitted that the settlement was legal and binding on the concerned person who put his signature on the settlement in the capacity of dependent son of J.P. Singhania. As per the settlement, they accepted that they are gainfully employed in the own family business, and the widow J.P. Singhania and two sons did not press for their employment under their management. They disclosed that after the settlement, money was paid to the widow of J.P. Singhania. In terms of the settlement, and in spite of that settlement, the petitioner workman filed the present case with the motive of getting employment as afterthought, and they approached the sponsoring union for making out a case on their behalf. They submitted that the settlement which entered in between the parties is binding, and accordingly the instant reference case which has been initiated has to be treated as invalid, illegal and without any jurisdiction. Accordingly, the same has to be rejected, sir. Points to be decided: whether the demand of the union for employment of Anand Kumar Singhania as dependent son of late J.P. Singhania by the management of NIRSA area of ECL in terms of CHGIT award in reference case number 310 of 1986 is justified. If so, to what relief is the said workman entitled? It transfers from the record that the sponsoring union, with a view to substantiate their claim, examined one witness as workman witness number 1. Management 2, in support of their claim, examined one witness, that is management witness number 1, considering the fact, disclosing in pleading of both the side evidences of WW1 and MW1, and also considering the document as exhibit such and such. I find no dispute to hold that one J.P. Singhania was cashier in Shampuri Colliery of Messrs. ECL, and he was dismissed from service by the management with effect from 3/8/1992 for the alleged defalcation of management money. Being agreed by the said order of dismissal, said workman J.P. Singhania raised an industrial dispute for conciliation, which ultimately resulted reference before the tribunal by the management for its adjudication. After receipt of the said reference, it was registered as reference case number 310 of 1986. Said reference case was ended in award by my predecessor in office dated 27/2/1992 with following observation. For the reasons stated above, I am to hold that the concerned workman was not guilty of any embezzlement and he deserved to be reinstated in service with full back wages. But since he has already died, the management may take a compassionate view of the matter and give employment to his dependent son as per the rules and procedures. We were agreed by this part of the award, Your Worship, because it was beyond the terms of the reference. The management will pay all the back wages and other consequential benefit to Urmila Devi, wife of late Jyoti Singhania, the concerned workman from the date of his dismissal to the date of his expiry within 1 month from the date of publication of the award. This part has been complied by us. Copy of the award during the evidence of WW1 was marked as Exhibit W1. It is contention of the management that during the pendency of implementation of the said award, on being approached by widow Sri Urmila Devi and her 2 sons for amicable settlement of the dispute, they did not prefer any writ petition against the award passed by the learned tribunal. On the contrary, they entered into an amicable settlement with the widow Urmila Devi, son Anand Kumar Singhania and Arun Kumar Singhania in presence of the union leaders as per the terms and condition of the said settlement. As the said settlement was agreed upon, the signed copies of the same will be filed before the ALCC, Dhanbad Central Government Industrial Tribunal Dhanbad, and the copies of the settlement will also be handed over to the late legal heirs of JP Singhania and other concerned. The said settlement during evidence of MW1 was marked as Exhibit M1. It is contention of management that as per the terms of the said settlement, they have cleared up all the dues of in favor for Urmila Devi, though voucher number itna, the said voucher was marked as Exhibit M2. After the said settlement, the petitioner workman raised the industry to dispute as the management failed to comply with the direction of award passed by the tribunal dated 27 February 1992. I have carefully considered the written statement submitted on behalf of the petitioner workman, and the written statement is absolutely silent about the existence of any settlement. यहाँ पर ये लोग suppress किए, which was entered in between the management.
The award has in detail dealt with such a settlement,
Yes.
and the award says that such settlement is hit by law.
Yes, by 58(4) of the rules.
Now you
My-
just see,
Yes.
are you serious about challenging this award?
Yes, Your Lordship.
Because in the previous award, there was a direction to make payment from 1992 to the dependent son. Have you seen it?
That payment has been made. Your
No,
Lordship.
no.
We are
Just
not.
a moment.
Yes.
You just have a look at this. You see page number 42.
Page number
42.
42. Yes.
There is a direction to the management to provide employment.
For considering for
No.
Yes, Your Lordship.
पेज नंबर 42 आइए ना पुराना अवार्ड देखिए
पुराना अवार्ड पेज 34
पेज 40 no 42 they wanted this just a moment
पहला अवार्ड
sorry
जो
sorry
है
पहला अवार्ड कहाँ है बताइए
पहला अवार्ड अनेक्सर 1 है
एनेक्सर 1 हाँ
जी।
उसका ऑपरेटिव पोर्शन
ऑपरेटिव पोर्शन पढ़ देते हैं पेज 30 इसका इंटरनल पेज है 7 paragraph 12 from the record I further find that the concerned workmen died during the pendency of their reference and order sheet dated etna will show that this petition to effect also filed request the tribunal for substitution of Urmila Devi, wife of concerned workman Srimati Urmila Devi was accordingly substituted. For the reasons stated above, I am to hold that the concerned workman was not guilty of any embezzlement and he deserved to be reinstated in his service with full back wages. But since he had already died, the management may take a compassionate view of the matter to give employment to his dependents. The word is may take a compassionate view. Therefore, it was to be considered by the direction that his case may be considered. And
So there
the
is no
second part,
direction
Your
to
Lordship, is
consider.
yes, Your Lordship.
So you say that there is no direction to consider, the management may take a compassionate
Yes,
decision.
Your Lordship. That is the may take consider it. We wanted to challenge this award, Your Lordship, but they approached us and said that we are not pressing for employment. Please make payment of the due amount that has already been paid.
And what is the final award in this case? The demand of the union?
Yes.
Read it, please.
That is annexure 5, page 48. It starts
Page 57.
and page 57.
I read it. Read it, please.
I'm just. Just previous page 56 से पढ़ रहे हैं.
ये ठीक है 56 छोड़िए ना खाली अवार्ड
Award. In the result, the following award is rendered. The demand of union for employment to Sri Anand Kumar Singhania as dependent son of late J.P. Singhania by the management of Nirsa area of Mrs. CCL in terms of the CGIT award, reference number 310 of 1968 is justified. Consequently, the management is directed to consider employment to the dependent son of deceased late worker J.P. Singhania in view of the observation made in the award passed in by my predecessor in office in reference case number 310 of 1986 within 3 months from the date of publication of the award in the Gazette of India. There is a repetition that his case may be considered. This is my written argument, Your Worship, a brief written argument.
What do you say to the settlement? What is your argument with regard to the settlement?
I have given the written argument, Your Lordship, paragraph 15 of my written argument, Your Lordship. I have stated that the finding of the learned tribunal in reference case number 125 of 1996 is bad and has been illegally decided in favor of respondent by impugn award for the reason that learned CGIT number Dhanbad has wrongly held that the management entered into a settlement in violation of section 19 and rule 58(4) of the ID Act. The same has no binding force and should be treated as illegal.
So you show something.
Yes, Your
You
Lordship.
have simply
Just
said that.
yes, I am coming. According to the writ petitioner, there was no requirement to enter into a settlement in Form H and communicating the same to the by the parties to the central government or appropriate government, since it was not a settlement in between the employer and the employer in terms of section 2P of the
It was
ID
not a
Act.
settlement in terms of.
No, not a settlement in terms of section 2P of the ID Act. Section 2P देखा जाएगा of the ID Act.
Such kind of settlement is, not permissible in the eye of law. You are considering the unequal bargaining power of the parties.
No, they approached us. They approached. It is not that we went and we were due to file our writ petition. They said, please do not file the writ petition. You make the payment. We are not pressing the claim for the reason that two sons are employed in the domestic business of the family. And Lordship may kindly see 2P for a moment. Section 2P of the ID Act. May I read? Settlement means a settlement arrived in course of conciliation proceeding. This is not the case, and includes a written agreement between the employer and the workman. Here in this case, this is not a settlement in between the employer and the workman. Workmen तो उस वक्त मर चुके थे. Therefore, this was not a settlement under section 2T of the Act. Therefore, not necessary to comply to be entered into Form H as required under Rule 58(4) and to send it to the government, Your Lordship, regarding the said settlement. वर्कमैन का भी डेफिनेशन देख लिया जाए, एस में है. Workman means any person including an apprentice employed in any industry to do manual, unskilled, skilled, technical, operational, clerical and supervisory work for hire or reward, whether the terms of employment be express or implied, and for the purpose of any proceeding under this act in relation to an industrial includes any such person who has been dismissed, discharged, retrenched.
What do you have to say?
Yes.
Yes, please.
May I place my argument that I have given by my written argument. Our first contention, Your Lordship, is the first award, that is Annexure 1, that is dated 27/2/1992, Your Lordship. The direction for considering employment of the son of J.P. Singhania was beyond the terms of the reference. This is my first argument. The second and the most important argument, Your Lordship, is that J.P. Singhania died on 13/4/1990 during the pendency of reference case number 310 of 1986. During the said period, he was not on the roll of the company as he was a dismissed employee. Since 2/8/1982, no compassionate appointment can be allowed to a dependent of a dismissed employee.
This dismissal order was set aside with all consequential reliefs.
With all consequential relief, yes. And we have narrated that the settlement, Your Lordship, dated 28/2/1986 by Srimati Urmila Devi and two sons, Arun Kumar Singhania son, forego their claim for compassionate appointment since they were engaged in the family business and they were not having any requirement for their employment. Thus, the second reference was barred by principle of acquiescence. Because of settlement dated Itna, no execution proceeding was ever filed by the legal heirs of the late J.P. Singhania or by the sponsoring union against the previous award passed in reference case number 310. Section 11(9), Your Lordship, and section 11(10) of the IDs Act 10 says how an execution proceeding has to be filed. Therefore, the second reference itself was bad. एग्जीक्यूशन केस के लिए आप सेक्शन 10 का एप्लीकेशन नहीं फाइल कर सकते. आपको फाइल करना होगा सेक्शन 11(9) का और 11(10) का. 11(9) और 11(10) हम पढ़ देते हैं.
आप हमको बताइए respondent. You tell us. There was already an award in your favor, undisturbed. Why a fresh reference?
Yes, it was
and
not
suppressing the fact that there was a settlement. Why didn't you file an execution?
Yes, 11(9), 11(10).
Why didn't you file an execution?
Why it accrued to the dependent?
Yes, there was a direction.
Is the subject matter of the present reference.
No. You see, you can't have both the things. You say you filed a fresh reference by saying that the order passed earlier should be complied. That was your fresh reference, isn't it?
My lord, since they were not, my lord, giving employment to the dependent, he had no other alternative.
No, you had an alternative of filing an execution case because there was already an award in your favor.
Award can be implemented under section 33(c)(2) only.
No, that is only computation of wages.
Yes.
So far as implementation
And
of
other
any
things
other
are-
direction in the award is concerned, the same can be executed through execution proceedings.
And my lord, the settlement which by
No,
learned
we are
friend is saying,
don't go to the settlement. You just tell us. there was already an order for consideration of your case,
Yes.
right? For and apart from that,
My lord, let us
it
go
was
to
just you just look at the award
Yes.
which you wanted to implement through another reference. There is an order, there is an award. You wanted that award to be implemented through another reference, correct?
my lord, all these are matters of evidence.
No,
That's why,
it is
my
a
lord,
matter of on the face of it we are looking at it. There was an award. The reference was to implement that award, isn't it? What is the terms of reference? You just
My
have
lord,
to
yes.
look at it. The reference was to implement that
Yes.
particular award only. Whether the demand of union for employment of Shri Anand Kumar Singhania as a dependent son of late such and such by the management of such and such in terms of CGIT award in reference number such and such is justified. Basically, through a new reference, you wanted execution of the earlier award.
Which is not permissible.
my lord, kindly have a look at the terms of the award.
ये है तो पेज नंबर एनेक्स पेज 48.
48.
Look at that.
Annex 5.
Whether the demand of the union for employment of Sri Anand Kumar Singhania as dependent son of employee by the management of Nexia area in terms of CGIT award in reference to justified. So, to what relief is the work but entitled?
Yes.
So, my lord, kindly have a look to section 11 again. Let us read, my lord. Where it says, section 11(1), subject to any rules that may be made in this behalf, an arbitrator, board, labor court, tribunal, national tribunal shall follow such procedure as the arbitrator or the authority concerned may think fit. Next, a conciliation officer or a member of a board or court or the presiding officer, labor court, tribunal or national tribunal may, for the purpose of inquiry into the existing or apprehended industrial dispute, after giving reasonable notice, enter the premises occupied by any establishment to which the dispute relates. ये भी नहीं लागू होता है. Every board, court, labor court, tribunal and national tribunal shall have the same powers as are vested in civil court. ये भी अभी तो माने लागू नहीं होता है in strict sense. Next, a conciliation officer may enforce the attendance of any person for the purpose of examination of such person or call for and inspect any document which he has ground for considering to be relevant to the industrial dispute or to be necessary for the purpose of verifying the implementation of any award or carrying out any award, verifying the implementation of any award or carrying out any other duty imposed on him under this act. And for the aforesaid purpose, the Constitution shall have the same powers as are vested in civil code under CP Civil Procedure Code 1908 in respect of enforcing the attendance of any person and examining him or compelling the production of documents. ये मुझे compel कर सकता है कि आप ये production
नहीं why are you reading section 11?
The court, labor court, tribunal may, if it so thinks, appoint one or more person having special knowledge of the matter under consideration as an assessor or assessors to advise in the proceeding. All conciliation officers, members and board and the presiding officer of a labor court tribunal shall be deemed to be public servants. But यहाँ कहीं नहीं बोला है कि ये implement कर सकता है, उसके लिए penal provision है. For that penal provision, section 19 is there.
Sub rule 9
They
देखा
are
जाना.
not on that. I am just asking you. There was already an award in your favor to grant you compassionate appointment. Then why a second reference was required?
It cannot be.
For an your entire case was that there is already an award. They are not implementing, so pass a fresh award. Is this the law?
But that reference was not challenged at any point of time
You
before
need
this
not
or
be,
not.
but we are looking at it. Need not be. The reference was not challenged. Very well. But there is already an award because you wanted a fresh reference to be decided to implement an award passed in an earlier reference.
But because, my lord, it's a case of fresh cause of action. It's a case of fresh cause of action. My lord, right accrued to the concerned
No,
workman.
it accrued to you. You never filed any execution case. You filed a fresh reference.
Only two options before the, my lord, any benefit, my lord, accrued to any person. If the wages can be computed in terms of money, then, my lord, section 33 And
This is not
otherwise, my lord, there
related
is
to confirmation
penal
of
provision.
case.
Here it is not a case.
There is a provision for execution of award, or there is no such provision for execution?
As there is penal provision.
No. For execution of award, they can execute it.
11.9 देखा जाए
हाँ,
11.9 पढ़
11.9
दीजिए
स्पेसिफिक नहीं है.
अरे क्या स्पेसिफिक नहीं है? अगर कोई डायरेक्शन होगा कॉम्पैशनेट
Every award
अपॉइंटमेंट
made
देने
under
के लिए,
this
कोर्ट इज
settlement,
11.9
पावर्स
order issued or settlement arrived at by labor court tribunal shall be executed in accordance with the
Yes.
procedure laid down in execution of orders of decree of civil court and such and such.
and 10 पढ़ दिया जाए लेबर कोड
Every order can be executed. Why only in terms of money? Suppose a person is to be reinstated. Suppose a person is to be reinstated, right? And he is not reinstated. What is the consequence? There will be another award.
It is, if not reinstated, my lord, he will be
He will be what? He will file execution
he will
case.
be given all the benefits, my lord, which can
He
be
will
computed
file
in terms
an
of money.
execution case.
My lord, he will be given all the benefits which can be computed in terms of money.
If a person is to be reinstated
And
and
your
the
lordship-
management is not reinstating it,
And
Then
your lordship-
11.10
what
will
is
be
the remedy?
11.10 वो सिविल कोर्ट में भेज देंगे और इट विल बी ट्रीटेड एज अ डिक्री
penal provision.
No.
उसके लिए
Penal
section
provision
9
भी है।
Please.
नहीं, ऐसा नहीं है, ऐसा नहीं है कि पेनल्टी सिर्फ होगा, नो.
हाँ, उसके लिए तो लेबर कमिश्नर के पास ये जाएगा, वो क्रिमिनल केस होगा, सेक्शन 19 में
He has to
जाएगा.
be reinstated. He can't get away with that. He has to be reinstated.
ऐसा तो हम देख के नहीं सुने नहीं,
Execution किसको बोलते हैं? Execution is not only execution of a decree in terms of money. It is not a money decree to be executed. There are so many orders passed by the learned labor court. Order of reinstatement.
if it is not implemented, my lord, the
Then
award of
there will be a
reinstatement,
fresh reference. इससे भी क्या होगा?
Penal
Implement
provision है, penal provision है.
पहला reinstatement was not accepted, and no such relief was given by the management in spite of an award. And if the management does not do it,
and this
there will
part
be a
was-
fresh reference.
and this reference was never challenged, and now at
Need
the
not be. We are looking at it, and you suppress this fact that there was a settlement.
they are saying that is not a settlement. 2P, as per 2PP, my lord, an award shall remain in force unless substituted by another award. Section 18 says.
जो इसमें खाली 11.9 और 11.10 हमको पढ़ने दिया सेक्शन 11.9 and 11.10
And my contention is, my lord, it was never challenged. The reference was never challenged.
We are looking at the reference of how it has
11.9
been answered.
original पढ़ Every award made, order issued or settlement arrived at, by or before the labor court, tribunal or national tribunal shall be executed in accordance with the procedure laid down for execution of order and decree of a civil court under order 21 of the CPC. 10. The labor court or tribunal or national tribunal, as the case may, shall transmit any award, order of settlement to a civil court having jurisdiction, and the civil court shall execute the award, order or settlement as if there was a decree passed by it. And moreover, because of the settlement, the agreement arrived in between the parties, your lordship, we were stopped coming to the High Court, challenging the first award, that is Annexure 1, your lordship, with respect to consideration of the case of the dependent of late J.P. Singhania for employment. Other part, your lordship, we complied, your lordship. The payments were made, that is not in dispute. And now, your lordship, 34 years have elapsed from the date of death. The date of death is 1990. 34 years have left. And moreover, at the time of death, your lordship, this employee was not in our role, your lordship. Therefore, my contention is that the second reference itself was not maintained.
In the first award,
Yes.
the direction was that the management may take a compassionate view of the matter.
Yes. Only to consider the case. And this part we wanted to challenge. And because of Annexure 2, the settlement, the agreement
There
in
was
between,
no direction to
give employment.
give
No,
employment.
only to consider.
That too may take
May take.
and may not take.
Yes.
It goes with that.
And we did not approach this Honorable Court because of the agreement that is Annexure 2. They said that you please do not file writ petition. Your Lordship may kindly see Annexure 2, the terms of the terms and conditions of settlement. The first says the management will not file any writ petition challenging the aforesaid award and will pay the full back wages of late J.P. Singhania for the period from 2/8/1982 to 13/4/1990. To wife of late J.P. Singhania within 15 days.
I'll dictate it in the second half. I'll go through the record once again.
Place some judgments.
Yes. You just fight which judgment you want to cite.
Yes. My lord, the orders of our, like, one is, my lord, 2015
You
volume
give
9
me the
SCC.
judgment.
Paragraph
2015,
volume 9 SCC, page 62. Paragraph, my lord,
2015, 9 SCC
62.
page 62.
62,
Paragraph 50.
paragraph 50. What does it say?
The award passed. The award passed by NIT is binding upon the corporation till it is substituted by another award or replaced by another settlement in relation to the service conditions of the workmen of the corporation in accordance with law as provided under section 12, section 18(3) of the Industrial Disputes Act, or another award that is required to be passed by the jurisdictional CGIT in relation to the above subject matter after the awards which are in operation are terminated by either of the parties as provided under section 19(6) of the Act. Until then, the said award passed by NIT will still be operative in law. Therefore, the same has been rightly applied to the fact situation on the hand in the award passed by CGIT and it would not have been set aside by the High Court. Thus, we are of the opinion that the learned single judge erroneously set aside the award passed by CGIT and the said judgment of the learned single judge has been further erroneously affirmed by the division bench of the High Court. The said judgments of the High Court are clearly contrary to law and legal principles laid down by this court in the cases referred to. Then, my lord, another division bench order of this honorable court. My lord, relevant paragraphs are page 7, 9, page 7, 9, 10, my lord, one
This
judgment
is
of
para number or page number?
my lord,
Para. Para 7, 9 and 10.
my lord,
What do you
the
want to say?
division bench order.
Yes.
Para 7, In this case, settlement was in Form H, but in our case, that is not the case.
You just tell us, can there be a settlement in terms of the Industrial Disputes Act
Yes.
between the management and the legal heirs of the deceased? Whether such a settlement will come within the meaning of settlement under the definition
और
of
better case है
industrial-
मेरा.
हाँ तो बताइए ना, बेटर ही बनाइए ना भाई, हम लोग
Then
इशू
it's a
डिसाइड
better
करते हैं
case.
किसका
If-
फेवर में
if
कितना
it is
बेटर
not
होने
at all
वाला
a
है
settlement, then they cannot substitute this award. Yes, तब तो मेरा और better case.
हम आपको कहाँ बोल रहे हैं कि आपकी हमेशा आपके अगेंस्ट में बोलेंगे. You just tell us. His contention is that that was not a settlement. Therefore, non-compliance of the provisions of
In
Industrial
representative-
Dispute Act was not fatal to their case.
In representative capacity, settlement can be a right.
Of the legal heirs also, rights of the legal heirs also.
Yes, they are the, my lord,
See the definition of the term
section 2P.
settlement. Settlement. Settlement का definition में, it is a settlement either between the union
and the workman.
and the workman, right? Or it can be a settlement between either the union will enter into settlement or the workman will enter into settlement. But here is a case, the settlement is not facilitated by the union,
Then not at all a settlement.
not at all a settlement, right?
Yes.
Okay. Therefore, in such circumstances, this is not a settlement. So therefore, no requirement in terms of section of the ID Act.
And the whole case was before the tribunal on settlement.
They
And
insisted
what
on
award?
enforcement of the settlement.
Yes. And award is simply may consider.
But initially, the award was may consider.
And there are
Subsequently, there is a direction to consider.
no may consider.
No.
No, second
Second award is may consider.
May consider.
No.
Yes.
You just see.
Last quote.
Same, to consider.
Directed to consider.
Direction to consider. May
Employment of
consider
the
and
award
direction to consider में फर्क है ना?
in view of the observation made by the awarded. So therefore the finding जो सारा चीज दिए 58(4) में, that is bad.
His contention is something else. If the entire finding is bad, then that particular settlement which you say is a settlement is no settlement in the
They
eyes
say
of
it
law.
is an agreement, not a settlement. This is an agreement with the dependent of Mr. J.P. Singhania with the employer, that they are not going to press. Therefore, the law of acquiescence will follow it. And the second reference
It
itself
was
is
an
not
agreement inter se between the parties.
parties.
It
right.
was not their case. It was forcefully done.
No.
That was not their
No,
case.
not at
So
all.
even if it is not a settlement, according to you, it is an agreement
Well,
between the
there is-
parties, and therefore
Therefore, no requirement for compliance of
My lord, there
58(4),
is-
Your Lordship.
my
Therefore,
lord,
the
there is
judgment
judgment.
that has been relied upon is not applicable in
My
this
lord,
case.
there is judgment that, my lord, these terms of settlement or agreement was not read over to the my lord, parties in Hindi.
it
Because
is
they are-
not
they
your
are signature.
case. It is not your case.
ये
You see, firstly,
इधर उधर का बात कर रहे हैं, हम भी इधर उधर का बात
इधर
कर
उधर
रहे
का बात नहीं कर रहे हैं. Please don't say that. Right? इधर उधर का बात नहीं कर रहे हैं. His
Settlement-
contention is that they said that there was a settlement. The parties agreed for this kind of arrangement amongst themselves.
settlement, not agreement. Now they are saying agreement. Before the tribunal, their contention was it is a settlement.
And what you say that the observation that it may be considered.
may
Now there is a
consider.
direction for consideration.
May
अभी भी may
direction to
चलेगा.
consider. Direction to consider.
Yes. And
Consider-
here it
and
was
what is the
absolutely
meaning of
optional.
consideration? They may accept it or reject it.
Consider the employment dependent son of deceased workman J.P. Singhan in view of the observation made in award passed in by the predecessor in office
they
in
can
reference case
accept it or
number.
reject
Therefore,
it.
it is a repetition of what was in the first award. Just
But may
repetition.
consider.
May consider.
It means may not consider.
May not consider.
May consider means may not consider.
Huh.
But the direction to consider is they have to consider and they may reject it.
Huh.
There is a difference
Yes,
between
yes.
the two.
Yes.
It's not one and the same thing. Mutation, second one, please. Industrial dispute का definition है industrial dispute.
K.
Dispute between
Industrial
employer-
dispute means any dispute or difference between the employer and employers, between the employers and workmen, between the workmen and workmen, which is connected with the employment and non-employment in terms of the employment, or with the condition of labor or any person. So dispute between the employer and between the employer and workman. वहाँ पर dependent of the workman नहीं है.
नहीं, ये जो compassionate
for
appointment का
non-employment.
compassionate appointment का जो consideration है, if you say that non-employee का कोई right नहीं है, तो industrial dispute in connection with compassionate appointment will not lie. But the industrial dispute has been worded in such a wide manner that it includes all the employment conditions of the employee, and one of the employment conditions is the compassionate appointment if it is available as per the terms and
My lord, in
conditions.
Coal India, my lord, this is called dependent employment, not compassionate appointment.
Yes, dependent
employment, NCW.
NCW, which
My
is
lord,
a binding.
This is my written notes about.
Therefore, the findings that has been given in the second award unit with respect to non-compliance of 58.4, that was not required because this was not a settlement under
ये record किस
definition of 2P और 18 भी देख लिया जाए.
चार
Section
पे.
18 जी चार.
चार पे.
Section
अब
18.
जो आप सबमिशन दे दिए हैं,
हाँ हम दे दिए.
बस
उनसे
आपने भी
कहीं
अपना
बाहर नहीं
submission
जाएंगे.
डिक्टेशन के समय डिस्टर्ब मत कीजिए.
बिल्कुल.
बीच बीच में कुछ भी मत बोलिए.
हम उधर बैठे.
हाँ, उधर क्या
हाँ.
बाहर भी बैठ सकते हैं.
मैं बोली हम बाहर ही बैठे.
क्योंकि बीच बीच में आप
नहीं.
इतना डिस्टर्ब करते हैं ना कि आपके ऑर्डर्स करेक्शन
इसीलिए
करने में
हम-
मेरा दिमाग खराब हो
हम-
जाता है.
इसलिए हम बार-बार बोल रहे हैं, let him conclude. हम बार-बार यही बोल
नहीं
रहे
नहीं
हैं.
हम तो फिर बाहर ही बैठे.
मैंने बात
इनका
दी
satisfaction
है, लेकिन कुछ भी एरर होगा तो फैक्ट का एरर आप दिखा सकते हैं, क्योंकि
एक-
बाकी जो आपको बोलना है आप ऑलरेडी बोल चुके
हम बोल दिया. पूरा रिटर्न सबमिशन मेरा चाहिए.
अब खाली एक सबमिशन है मेरा उसे कि रेफरेंस वाज नॉट अंडर चेक अबाउट के
आई विल टेक. आप रहिएगा,
और उसका रिप्लाई
अभी
हमारा
आप
है.
सोचे नहीं है क्या करेंगे, इसीलिए आप रहिएगा. हाँ.
हमारा उसका रिप्लाई है कि हम लोग को वी वर स्टॉप चैलेंजिंग दैट.
That's right.
Item 6, WPL 1169 of 2018, along with item 7.
You're there for the other side.
The instant review petition has been filed in the nature of certiorari for quashing of the award. The award is at page number 69.
आप इतना lost क्यों हैं? Okay, are you ready? This case was mentioned yesterday, and at this instance we have placed it today such that we at least find out whether you are ready, not ready.
What's it after vacations?
आप कौन सा vacation? 2025,
ये दिवाली
21-25,
दिवाली vacation.
after 21-25.
दिवाली vacation.
नहीं, क्यों ऐसा? ऐसा नहीं हो सकता. ऐसा इतना लंबा डेट नहीं हो सकता.
ये
बहुत हो सकता है तो नेक्स्ट वीक हो सकता है.
petitioner is under treatment. He has broken his leg. So I have to
He has given you वकालतनामा, right? काफी है. उसमें आपको क्या किसकी जरूरत है आपको पता नहीं?
थोड़ा
Why do you need?
ब्रीफ कंटूस मैटर का बता देते हैं.
नहीं ब्रीफ पर दूसरा बताने का क्या ही फायदा है. This case is covered.
This case is covered. There are two issues. There are two workmen. I'm starting with the WPL number 1169 of 2018.
आप थोड़ा 2 मिनट सुनिए. Okay?
Annexure 6, that is the page number 69.
Page number
69.
60. Yes.
Leadership, here we are concerned with both the complaint cases, that is the complaint number 7 of 2015 and complaint number 4 of 2015. In this, the first workman, that is the SN Singh, he was discharging his role as assistant grade 1 depot in Food Corporation of India, and the second workman is Jitendra Chand Modak. He was discharging his duty as assistant grade 2 depot in Food Corporation of India. Now, Your leadership has already, while sitting in division bench, has already settled that assistant grade 1 of Food Corporation of India do not fall under the definition of workman, and the same has been set at rest by the Honorable Supreme Court. That the SLP is preferred by,
aside?
yes. No, the SLP preferred by the workman was dismissed.
So now
Meaning
that particular designation does not come within the
under the
definition
definition
of
of workman. That was the LPA number
So
446 of 9.
these two private persons, they are of the same category.
No. There are two distinct categories. There is a fine distinction between both of them. The first workman, that's why I'm using.
Okay. First workman, Lalan Prasad Singh.
He was ex assistant grade 1 depot.
Okay. He is covered.
He is covered by LPA number, by the decision of in LPA number 446 of 2019.
446 of
2019.
2019.
This was passed on 4th of August 2023.
23. SLP dismissed on?
SLP dismissed.
Anyways, SLP dismissed.
SLP dismissed by simple one-line order that there is no merit in the special leave petition. The special leave petition is accordingly
Order
dismissed.
भी याद हो
हाँ,
जाता
याद है, एक लाइन
By
का
heart.
याद है. ये हुआ और दूसरा वर्कमैन
शिव शंकर, हाँ.
शिव शंकर सिंह असिस्टेंट ग्रेड 3 डिपो इसमें he is also covered by decision in WPL number 2703 of 2018.
2703 of 2018.
18. This was passed on 1/7/2024.
ये किसने क्या हाँ पास?
आपका ऑर्डर है.
सर ये भी फाइनल हो गया?
ये भी फाइनल इसमें अभी तक I'm just passing on. LPA का टाइम खत्म हो गया. LPA फाइल नहीं हुआ अभी तक. Your leadership has mainly decided it on. Things would be various judgments have been discussed right from the Blue Star and the Straw Boards, Jaipur Jilla, everything has been considered. And finally, the operative portion is at para 20 and 21. I may be permitted to place certain lines. The court is of the considered view that allegations in the disciplinary proceeding with regard to fake procurement of rice has no connection whatever with the general dispute between the workman and the present petitioner, and therefore it cannot be said that dispute in connection with fake procurement was linked with the overtime allowance. The court is of the considered view that merely because the order of the punishment which has been imposed as a consequence of the disciplinary proceeding has a bearing in the pay scale of the respondent and consequently may have bearing in the overtime allowance, the same is not sufficient to maintain a petition under section 33 of
This
the
is
ID Act.
basically if there is a pending dispute whether
Yes.
this permission is required to be
Required,
taken or
yes.
intimation is to be taken.
Required.
But so far as petitioner number 2 is concerned, whether he is otherwise covered under the provisions of Industrial Disputes Act.
No, he is not covered because
Yes.
things would be clear if your leadership comes to the punishment order. What punishment was assigned to him?
Okay, we'll see that.
Yes.
Okay, so and what about the other writ?
The other rate that is the next one. The next one that is the first workman, that is the SN Singh. He is discharging his duty as assistant grade 1 depot.
So petitioner
again-
number 1 is covered.
Petitioner number 1 is covered in view of that LPA judgment.
ये दोनों में सेम ही ऑर्डर लगाते हैं.
हाँ, दोनों में ये हुआ क्या था, ये लोग का एक मिसकंडक्ट था, एक प्रोसीडिंग चली, एक पनिशमेंट ऑर्डर, कॉमन पनिशमेंट ऑर्डर.
नहीं तो ये जो दूसरा केस में इसमें भी तो ललन प्रसाद सिंह एंड शिवशंकर का ही ऑर्डर लगा हुआ है.
हाँ, उसके नीचे देखा जाए.
अच्छा उसके नीचे.
Complaint number 7 of 15.
हाँ बताइए.
उसमें-
SN Singh is covered according to
SN Singh is covered in view of the LPA number 446 of 19.
Okay.
And this second one, Jitendra Chandra Modak, is also covered in view of WPL number 2703 of 2018.
ये थोड़ा सा डाइसी है.
वो हम एक्सप्लेन कर देंगे. पनिशमेंट ऑर्डर एक बार देख लिया जाए.
ये हम देखेंगे. पता आप सुन लिए ना, इतना ही है इनका बहस.
33.
एक केस में बोलते हैं कवर्ड है, दोनों में से पिटिशनर नंबर 1 इज कवर्ड बाय LPA 446 ऑफ 2019. इनका जो ग्रेडिंग है इज कवर्ड बाय दैट जज. इन ग्रेडिंग वी हैव मेड दैट ही इज नॉट अ वर्कमैन एंड देयरफॉर ID एक्ट विल नॉट अप्लाई. राइट, दैट हैज अटेन्ड फाइनलिटी. फूड कॉर्पोरेशन का ही है, दूसरा का केस भी नहीं. ओके, दे हैव यूनिट्स ऑल ओवर इंडिया. Same credit चलता है इन लोगों का सब जगह. So far as the second petition is concerned, वो WPL से बोलते हैं covered.
रिडक्शन इन पे का था. रिडक्शन इन पे का था तो लीडरशिप हैज पास्ड अ डिसीजन दैट इन 33(2)(b रिडक्शन इन पे किए तो देयर हैज टू बी अ कनेक्शन विद द मिसकंडक्ट. इफ द मिसकंडक्ट इज नॉट कनेक्टेड द एम्प्लॉयर मे do the needful, may discharge or punish the workman, and if and only if there is a punishment of dismissal or discharge, then only in such circumstances the post facto approval is required. If the punishment is any other punishment except dismissal or
Only an
discharge,
intimation.
then only not only
Not only and even that is also not.
even that is also not required. That has been यही जो दो पैरा हम बोले
नहीं
पैरा.
तो यहाँ पे तो 33 का प्रोसीडिंग है क्या?
हाँ 33 का प्रोसीडिंग है.
यहाँ पे 33
का ऊपर में ही लिखा हुआ अवार्ड में देखा जाए ना. In a complaint under section 33.
Oh, it is a complaint.
Complaint 33. It's not a reference under section.
It is not a reference. बताइए कब करेंगे? दोनों जजमेंट पढ़ लीजिए, समझ लीजिए, इसमें आपको क्लाइंट का क्या काम है. अगर वो बीमार है, अच्छा है, उनके लाइफ टाइम में डिसाइड हो जाएगी. सब पुराना केस 97 का केस है. नेक्स्ट देखिए, the learned counsel for the parties are present. The learned counsel for the petitioner in both these cases submits that WPL number 5467 of 2017 arises out of complaint case number 77 of 2015 and WPL number 1169 of 2018 arises out of complaint case number 4 of 2015. He submits that petitioner number 1 that the case of the petitioner number 1 in both the cases.
WPL 1169 arises out of complaint case 7 of 15.
अच्छा उल्टा है.
7 of 15. हाँ.
1169
arises out of
out of
complaint
7 of 2015 and the other one 5467
This arises out of 4 of 15.
4 of 2015. The learned counsel submits that the applicant in complaint case number 7 of 2015, namely the first applicant in complaint case number 7 of 2015, namely SN Singh, being of the category ex manager.
No, यहाँ गलती एक लिख दी है. अवार्ड में एक्स मैनेजर डी लिख दी है, बट ये एक्स मैनेजर डी थे नहीं, ये असिस्टेंट ग्रेड 1 डिपो है. पनिशमेंट ऑर्डर में लिखा हुआ है. एक लोग पनिशमेंट ऑर्डर देख लिए.
We'll see that. And applicant number 1, namely Lalan Prasad Singh, in complaint case number 2015, were not employees within the meaning of, were not workmen within the meaning of Industrial Disputes Act. He submits that this point is covered by the judgment passed by this court in LPA number 446 of 2019. He has also submitted that the judgment that the SLP filed against the state judgment has been dismissed. So far as applicant number 2, namely detained Chandra Modak, in complaint case number 7 of 2015, and applicant number 2 in complaint case number 4 of 2015, namely Shivshankar Singh, are concerned, their case itself was not maintainable, and this point is covered by the judgment passed by this court in WPL number 2703 of 2018, passed on 1/7/2024. Mr. Rahul Kumar, ऐसा लग नहीं रहा कि एचपी नहीं फाइल हुआ.
नहीं, चेक किया है मैंने.
होगा, कर रहे होंगे. We do not know.
हो सकता.
The counsel for the respondent prays for time, and he submits that the matter be listed for final disposal on next Wednesday. Post for
Thursday कर दीजिए, Wednesday I'm not available.
on next Thursday. ठीक है? Post these cases for final disposal. इसका record भी आया है क्या? नहीं आया है?
There was a direction on 8th January for calling the LCI.
आया है? यही है। दोनों केस का होगा। एक ही साथ disposal होगा।
एक ही साथ disposal.
From various for final disposal item 1, the PC 4347/2009.
क्या है? पार्टी करते हैं? क्या है? Not before.
Item
आप
2.
इसके लिए बैठे हुए हैं, not before में कराने के लिए।
Item 2, the PC 6051/2015.
Connection 8 and connection 10 attached to the supplementary affidavit. Connection 10, both are under check. Connection 8 has been passed under section 7A of EPF Act 1952, directed the petitioner to pay a sum of rupees 1,42,000 and odd. And Annexure 810, Annexure 10.
Supplementary affidavit. Why this order has been placed on record by supplementary?
Due to inadvertence, that was not filed along with the petition, and thereafter a supplementary affidavit was filed, bringing the same on record, though it was under challenge in the petition.
I don't get this.
It is
When did you file it?
23/1/2017.
Yes. Annexure 10.
Annexure 10 is the appellate order.
Yes. And where is the original?
Annexure 8 is at page 40
Of the main.
main writ application. Ladyship, I established a factory wherein the license was given for only 9 people to work at a time in the factory. It was established, the license was issued on 18/4/1998.
Yes. For 9 persons.
For 9 persons. It is as
Who issued the license?
it was issued under the Bihar Factories Rule.
Under the Factories Act.
Yes.
What is the threshold for EPF?
This ladyship, they say that my factory was inspected by them on 1999.
15 to 99.
99. That is Annexure 3.
Yes.
And they found that 21 employees were working. Ladyship, this is the second round of litigation here before the Supreme Court. Earlier, the order was passed before by under 7A by the competent authority, and that was challenged in WPL before this honorable court. And we were directed to move an application before the appropriate authority.
WPL number?
WPL number 2160 of 2007.
2160 of 2007.
Annexure 6 is the order.
Annexure 6. So the order of the order under 7A was set aside.
Is set aside, and we preferred a review. Annexure 5 is the first order
Yes.
at page number 27. That was an ex parte order wherein there was a direction upon me to pay 5,93,000 for the period.
Ex parte order, right?
That was an ex parte.
4804 ex parte.
That was order dated 30th of July 2004 by
Yes.
Assistant Provident Fund Commissioner.
3704/480. Right? This was challenged.
This
in
was
WPL number 2160 of 2007.
2007.
Where is the order?
Annexure 5 is at page number 27 and Annexure 6 thereafter.
Annexure 6.
Annexure 6 is at page number 30 and Annexure 5 starts at page number 27. That was the previous order that was challenged in WPA.
The Annexure 6. Okay. You were remitted for alternative remedy.
Yes.
Then you file your review petition.
I filed my review petition, that is Annexure 7 is the review.
Yes.
Thereafter Annexure 8 was passed. Ladyship, only in my review application, the grounds for the review may kindly be seen at page number 36.
Yes.
The grounds, the following grounds. A. On the basis of the inquiry report dated 24/2/1999, this factory has been covered under the EPF Act, but the aluminium utensil does not come within the schedule given in the Act. As such, the provision of the Act does not extend to the factory of the applicant. So my first ground is that utensil, I was making the aluminium utensil and that is not covered under Schedule 1 of the Act. Second is that the contention of the applicant that he has never employed more than 9 employees and this employment was given as per the license by the factory inspector. The factory Ranchi industry is not functioning and it has been permanently closed with effect from March 1999, and the liability imposed by the Assistant Provident Fund Commissioner under order dated 4909 is not maintainable. Thereafter, since the order under section 7A dated 4804 passed by the EPF Commissioner was not passed under the subsection 3 of section 7A of the Act as such, as per the direction given by the Honorable Jharkhand High Court, this review petition has been filed. So basically, I had 3 grounds, Ladyship. First, that the aluminium utensil is not covered under the Act. Second, 9 employees were never employed, more than 9 employees were never employed by me. And third, my factory has been closed from March 1999 itself. So thereafter, for the period up to 2003, this further amount could not have been assessed. Ladyship, now coming to Annexure 8. Under 7A, there are 2 heads in which an application can be moved, whether the Act is applicable or not, and secondly, the amount of the disputed, when I dispute the amount. Now, the entire order, Annexure 8, does not speak about how the Act has been made applicable when the grounds for the review is the same, that it is not applicable upon it. And second, the
This
amount.
is the first order of assessment after the inspection.
No, first order is.
You were issued a coverage letter.
Yes.
Thereafter, there was no assessment. This is the first one.
First one is
Inspection
Annexure
was
5.
conducted when?
First order is Annexure 5.
24/2/99. And they have assessed it for the period 299 to 7/20, 2003. This is your first assessment under section 7.
Yes, yes. The first assessment order which was challenged in WPL was Annexure 5 Leadership, and this was after the Annexure 8 is after the review application, which is still in existence. May I read out the order edition?
You have got the license renewed.
No, I say that I never got my license renewed. They say that up to 2002 the license was renewed. So
He
even
stated, you see, your submission is recorded, Sajjan Kumar Agarwal, right?
yes.
He stated that as per the records of factory inspector, the establishment license was renewed up to 5/1/2002.
Now, as per the this
This is your submission.
I said that in March 1999 he had submitted a closure intimation in form F29. May I read out the order?
Just a minute. You read the submissions here after the hearing dates.
हाँ, Shri Sajjan Kumar.
Yes.
Shri Sajjan Kumar Agarwal, proprietor on behalf of the establishment, Shri Shailesh Prasad, EO, Ranchi, and Shri Lalit Sangha, EO, Ranchi, on behalf of the department, appeared during the course of hearing. Shri Agarwal stated that the establishment was closed in March 1999 and he had submitted the closure intimation in F29 of Office of Factory Inspector. EO Shri Sangha stated that he had visited the Office of Factory Inspector but could not trace the copy of F29 in the office. He stated that as per the records of the factory inspector, the establishment license was renewed up to 5/1/2002 and the establishment was running up to 5/1/2002. This date is also important, ladies and gentlemen. 5/1/2002. Hence, the establishment is liable to pay EPF and allied dues up to 5/1/2002. In spite of providing several opportunities, Shri Agarwal could not provide any proof regarding the closure of the establishment on March 1999. The original 7A order made on 4/8/2004 was also perused. It appears that the said 7A assessment order has been issued ex parte on the basis of available records in this office. The office file reveals that one complainant Shri B.N. Jha appeared on 10/11/2009, but he did not provide any evidence which has been taken into account while making the assessment order. So B.N. Jha, who was the complainant, has never adduced any evidence before the authority. The undersigned has considered the available records and documents filed during the proceedings and the reports submitted by the enforcement officer for the assessment of the dues in respect of all the employees of the establishment.
They have assessed you till 2003.
2003.
Although in the order they say that
5/1/2005. Secondly, the complainant never appeared. Thirdly, by both the grounds, there is no whisper of the grounds and there is no finding of the court below with respect to whether the aluminium factory, which was doing the production of aluminium utensils, will be covered or not. Secondly, more than 9 persons were employed. No chit of document showing the list of 21 people as per them that they were working in my factory. Not a single document.
There is an inspection report.
They have brought it by way of counter affidavit, ladies. Supplementary counter affidavit after the direction of this honorable court.
What is the date?
Supplementary counter affidavit dated 2/9/24.
29?
2024 का.
The latest?
जी. इसका पेज 9 and 10. Has leadership gone? Page 10 will be relevant leadership. They have given the name of 21 employees because there was specific direction by this honorable court to bring the details of all 21 employees who are working in my factory premises. Only first name has been mentioned. My signature is not there.
No, it is.
No details.
This particular first annexure A reveals that verification labor employees 21 persons were found working in your establishment.
Yes.
No record, salary register for verification was produced. In order to examine the records, attendance return on
And thereafter this list may kindly be seen what they have prepared. No age, address, employee ID, if at all. Nothing, no full name, nothing, neither.
Where have you stated in your petition that 21 employees were not found? You may have a license of having 9 persons, but still you can employ more than that. That would be a violation of the license granted by the factories.
If I'll employ, then the EPF, that what they said, that would be made applicable because that
That's
is made
right.
applicable
So
only
where is your statement in your petition that you never employed 21 persons? Not in the main petition, in your review petition. Yes. Where have you mentioned?
It is at page number 33. Page number 33 of the main writ application, my review application, last paragraph niche mein revision, that the applicant states and submits that he never employed more than 9 employees in the factory. So these are my 2 grounds.
And you went before the appellate authority?
Yes, I
What
went.
did they do?
They have upheld the order, the review orders, and that the specific paragraph may kindly be seen, ladyship. At page 13 of the supplementary affidavit, to which annexure 10 has been annexed.
Para number 10.
Para 15 is the last but one paragraph of the order. May I read it? Admittedly, it is admitted case of the appellant that till today appellant has not filed any mandatory pro forma either before the inquiry officer or before the tribunal showing the name of its alleged 9 employees. When the appellant himself not appeared before this tribunal with clean hands, as the appellant wants to take benefit of alleged weakness of the respondent, that the appellant cannot allow to do so. So they admit that it is the weakness of the respondent that they could not produce the name of all 21 employees who were working at that point of time in my factory. And they say because I could not produce the name of 9 employees, this argument is not available to me, I cannot take this ground. This is their allegation. They saw 21 people working in my premises. There was one Jha who was the complainant. He never reduced any chit of document. He did not came and gave evidence before the court below. And I have been saddled with the liability beyond the inquiry date. If at all the inspection was done in the year 1999, how can a liability be saddled upon me beyond that period, 2003? And 2002, they admittedly they say that the factory was never renewed thereafter.
What do you say?
Supplementary court affidavit, paragraph 9.
You see, when they denied that they have not engaged more than 9 persons.
21% lordship, lordship. And receipt, page 9 lordship.
Page 9 is the
Signature
only
also lordship.
the page 9 does not mention that the list of 21 persons is enclosed. It does not mention that the list of 21 persons is enclosed.
Yes, lordship.
No.
third line also, proceed. Or fourth line. Physically verified. Verification of laborers and employee 21 persons were found working in youth.
Does it mention that list enclosed?
Yes, list out also please.
No, first page, does it mention that the list of workmen is enclosed? And what about this manufacturing aluminium items? It is covered? Covered or not covered? Schedule.
Schedule 1 may kindly be seen. They have made me covered under electrical, mechanical or general engineering products. But there is no mention of any utensil or aluminium work in the entire schedule. That is third in the list.
The schedule is under which section?
Schedule is
Under section 6.
the applicability has been mentioned. Section 1, subclause 3. 3A. May I read out? 3A. To every establishment which is a factory engaged in any industry specified in Schedule 1 and in which 20 or more persons are employed.
Where is the finding of the authority that it is covered under such and such? There is no finding?
There is no finding. They straight away say that.
There is no finding to that.
No, not at all.
But they are saying so in the counter affidavit.
They are saying so in the counter affidavit. There is only finding as per the order Milord, which is erroneous from my side, got my environmentals, that more than 21 employees were
These are two distinct things.
Yes.
If it is not applicable to aluminium utensil, then
Yes.
irrespective of the number of workmen,
there is no finding to that.
there is no finding by the appellate authority as well as the. This is one aspect.
Yes.
Correct? There is no finding by those authorities. You cannot improve it by a counter affidavit.
There is no finding.
Right? So this is one thing. There is no finding to that effect regarding applicability.
Yes.
Regarding number of workmen, 21 persons, but
In review application, in the order of the review in Annexure A, there is no finding to that extent as well.
as
that
to how many persons
were working. They straight away they have estimated, they have calculated.
Here also there is no finding.
There is no finding. He says that because I could not produce the list of 9 workers who were working in my establishment, so I cannot ask them to produce the name of 21 persons as per them who were working in my
That's
factory premises.
Now, third point is
Third point is, since the inquiry was made,
Factories Act. You see, you can go and conduct an inquiry you have power to summon anybody, right? You could have summoned the factory inspector to come and produce the documents, right? You could have examined him. Your officer goes to the office of the factory inspector. He comes up with an inquiry, and then he places it before the authority and the order is passed. You could have summoned the factory inspector, the authorities who are in possession of the property. What jurisdiction do you have to go? Do you have to go to the authorities of government authorities, there you look at their file and then come up with a with a stand that this document is not available in their record. It is they who would explain whether this document, the closure, is there in their record or not. And in your order only you say that the license was extended till a particular date. Whether it was extended, not extended is itself a question of fact. And you yourself say that it was to be, the dues were to be assessed only till February 2002, but you calculate the entire period till 7/2003.
Your Ladyship, even beyond the inquiry date,
That's
if
right.
the inspection was done in 1999, how come they are imposing the
No,
amount?
they will keep on calculating the amount subsequently, and they will treat those employees as your employees, and then they will keep on assessing it.
No further.
For the learned counsel for the parties, this petition has been filed for the following relief. The learned counsel for the petitioner submits that an inspection was conducted in the premises of the petitioner and a report was prepared on 24/2/1999. The report has been placed on record by the respondents in their supplementary counter affidavit. Dated 24/9/2024. 24/9/24.
2/9/2020.
2/9/2024. The report is dated 15/2/1990.
Yes.
As Annexure A, she submits that in the said report, it has been mentioned that 21 employees were found working. However, there is no mention that the list of employees was also prepared and was a part of the report. She submits that the first page of the report shows the receiving of the petitioner, but at the same time, a list of employees has been annexed to the report, said to be prepared on the same day, but the list of employees does not show any receiving by the petitioner. She has submitted that neither the report mentioned about the list of employees as enclosure, nor the list of employees gives any receiving of the petitioner. The learned counsel has further submitted that only on the face of the list of employees, only the first name of the persons have been mentioned without their parentage or address, and the identity of such persons is itself incomplete. She has submitted that an ex parte order under section 7 capital A was passed on 37/2024 / 48/2004, 37/2004 / 48/2004 within bracket annexure 5, wherein the dues of employees provident fund was calculated for the period from February 99 to 7/2003. The learned counsel submits that the said ex parte order was challenged before this court in WPA number 2160 of 2007, and without entering into the merits of the case, the writ petition was disposed of, enabling the petitioner to either file review or an appeal under the provisions of the Employees Provident Fund and Miscellaneous Provisions Act 1950. She submits that consequently a review application was filed in which it was categorically disputed that the petitioner never employed any number of employees more than 9 employees, and as per the factory license given to the petitioner, the petitioner was entitled to employ up to 9 persons. Further, it was also mentioned in the review petition that the factory is not covered under the Employees Provident Fund Act, as the aluminium utensils was a manufacture of aluminium utensils. They were manufacturing unit. Manufacture of aluminium utensils was not mentioned in the schedule to the Act. She has further submitted that the petitioner had also produced document to show that the factory license was surrendered and the factory was permanently closed with effect from March 1999, and therefore otherwise also any liability beyond March 99 could not have been imposed. The learned counsel submits that the aforesaid points raised in the review petition were not considered or they were not considered in accordance with law. She has submitted that a fresh order was passed on 3/11/2010, wherein the claim of the petitioner that the establishment was closed since March 1999 and intimation in F29 was given to the Office of Factory Inspector was disbelieved on the ground that the enforcement officer had stated that he had visited the Office of Factory Inspector but could not trace the copy of F29 in that office, and the license was renewed up to 5/1/2002, and that the establishment was running up to 5/1/2002. She submits that the authority under the provisions of Employees Provident Fund under the provisions of the Act of 1952 have got power to summon various persons to give their evidence, but the enforcement officer, having gone to the office of the factory inspector and inspection of the records was conducted, was not supported by any material except a mere statement of the enforcement officer. She submits that the authority of the factory inspector could have been summoned and the factum of filing of closure intimation in F29 could have been verified. She has also submitted that the date of renewal of factory license has also not been mentioned, which may have a bearing as to whether the renewal was done after the intimation of closure or it was prior to that. The Learned Counsel has submitted that the contention of the petitioner that they had never employed more than 9 persons have also not been considered and no such finding has been done. The Learned Counsel has further submitted that so far as the point of jurisdiction regarding coverage as raised by the petitioner by referring to Schedule 1 has also not been considered by time. She has submitted that an appeal was filed before the appellate tribunal against the order dated 3/11/2010, and the appellate authority after recording the submissions from till paragraph 6 has not considered the fact that the list of 21 employees did not contain the receipt or signature of the petitioner. And the other two aspects of the matter regarding applicability of the Act and the matter regarding filing of Form 29 capital 29 under the Factories Act has also not been considered. That has not been considered by the appellate tribunal.
पैरा 10 में ये कहते हैं undisputedly section 7A of the empowers the respondent to decide the disputes arising regarding the applicability of the act and further to determine the amount, but applicability of the
That's-
act thereafter has never been known.
The learned counsel submits that the plea raised by the petitioner in the review petition has neither been considered by the has not been considered. The aforesaid plea raised by the petitioner in the review petition has not been considered by the Regional Provident Fund Commissioner while passing order dated 3/11/2010, and out of the 3 points, only 1 point regarding number of employees has been considered by the appellate tribunal, and the appellate tribunal has not considered the fact that the list of employees did not contain the signature of the petitioner. Yes. The appellate tribunal has also not properly considered the points of the petitioner, and therefore the impugned orders call for interference, and the matter be remitted to the Regional Provident Fund Commissioner for fresh consideration. It has to be considered.
Premise बंद हो गया कब का 99 का है. The order should be set aside. That is my prayer.
The impugned orders are fit to be set aside.
Yes.
आपको क्या बोलना है? Remand करना है? The learned counsel appearing on behalf of the respondents has submitted that the points which have been raised by the petitioner in the review petition
99 में लेडीशिप फैक्ट्री बंद हो गया. अभी
आप
2054 में
if not considered by the authorities, at best the matter can be remanded. The impugned orders may not be set aside. He submits that the matter relates to dues relating to Provident Fund, which is certainly a beneficial legislation. After hearing the learned counsel for the parties and considering the submissions which have been recorded in detail, considering the submissions made by the learned counsel for the petitioner, which has been recorded in detail as aforesaid, this court finds that the order dated 3/11/2010, which was passed regarding on assessment for the period 2/99 to 7/2003, pursuant to order passed by this court in WPL number 2160 of 2006, reveals that the aforesaid 3 points have not been considered by the authority. The applicability of the act is a jurisdictional point which was required to be considered by the authority, and the finding was required to be given as to under which head the petitioner would at all be, if at all be covered under the schedule, or the petitioner would otherwise be covered under the provisions of the Employees Provident Fund and Miscellaneous Provisions Act. But no such finding has been returned by the Assistant Provident Fund Commissioner or even by the appellate tribunal. This court further finds that a dispute was raised with regard to number of employees were found working on the date of inspection, and the inspection report and the arguments have been advanced by the learned counsel for the petitioner with regard to the number of employees on the date of inspection, as recorded above. And such point was also raised by the petitioner disputing the number of employees, but the Assistant Provident Fund Commissioner has not recorded any finding with regard to the number of employees employed in the organization. This court also finds that so far as closure intimation in Form F29, which is said to have been filed by the petitioner in the office of factory inspector is concerned, the same has been disbelieved on the statement made by the enforcement officer who claims to have visited and verified the records from the factory inspector. But no such inspection report with regard to the office of factory inspector has been referred to in the interim order. And further, it was certainly open to the authority to issue summon to the factory inspector, who could have come and deposed regarding the correctness of filing of closure intimation in Form F29, so that even the petitioner could have had the opportunity to cross-examine the said authority, as the petitioner had produced a copy of F29 before the Assistant Provident Fund Commissioner, claiming that the factory was closed in March 1999. The impugned order does not even reflect as to when the factory license was renewed, whether it was renewed after the closure claim after March 1999 or before March 1999. This court also finds that the points raised by the petitioner in the review petition, aforesaid 3 points raised by the petitioner in the review petition has either not been considered properly or not at all considered as mentioned above, and these aspects of the matter have also not been considered by the appellate tribunal. Consequently, the order passed by the appellate tribunal as well as the impugned order dated 3/11/2010 passed by Regional Provident Fund Commissioner R.O. Ranchi within bracket Annexure 8 are hereby set aside, and the matter is remitted back to the Regional Provident Fund Commissioner for passing a fresh order in accordance with law, after granting an opportunity of hearing to the petitioner and, if required, summon the factory inspector with regard to the intimation in F29 regarding closure of factory, and also verify the status of the factory, and also verify regarding the renewal of license, if any, by the petitioner, factory license, if any, by the petitioner. The said authority would also give a specific finding in connection with the number of employees based on the materials which may be produced by the petitioner. You did not produce any documents, perhaps.
But for the relevant time period,
Certainly for the relevant.
for the relevant time.
You must be having.
Yes, whatever maybe I may be having at that point, that may be mentioned that because they may inquire thereafter.
No, of the relevant period
Ah,
involved in the present case, that is period 299 to 7-2003.
That way.
ऊपर लिखिएगा, it is also surprising that the authority at one place in the review order has recorded that the establishment would be liable to pay the dues up to 5/1/2002, but apparently the entire period from 299, but the period up to 7/2003 has been included. The petitioner to appear before the authority on appel. I give a date, you appear. 2 months. 2 months. The authority is directed to pass a fresh order in the light of this judgment and in accordance with law within a period of 6 months from the appearance of the petitioner to cooperate with the disposal of the matter. Yes, you have to say something.
May I mention one matter litigation? Serial number 11. There was a direction for physical appearance of circle officer Memorial.
Yes, come.
I am only praying your yes, your lordship.
It will be taken up. 11.
Yes, serial 11.
Why has he come?
Ladyship, there was a direction earlier for both the parties, petitioner and circle officer, to be remain physically present.
Both of them have come?
I don't know about petitioner, ladyship. I will inquire with them.
You inform the petitioner also.
Yes, sir.
You are there for the petitioner.
No, not in this one.
You have to say something.
But let's,
We'll take it up at 2:15. We'll take it.
for item 5 in the daily list, since 2-3 matters has been posted for 2:30 minutes, and there is a status quo order in the item 5 also. And the previous order, the state wanted to, since there is a requirement to place a report of the concerned officer. So,
The report has come.
no, we have received one letter also. Today also they have convened a meeting, the secretary and the concerned revenue authorities along with the project director NHA regarding resolving the issue. And as I was praying for 2 weeks
On the last working day, that order was passed. It's the same case.
Yes, yes. But,
So you are
I was
seeking
praying-
time.
Yes, 2 weeks time, Your Lordship. Because the entire
See,
records.
2:15 matters which we have already fixed. We'll take it up after some time. These two matters, we'll take up initially at 2:15. I'll come at 2:15. Yesterday I was making certain corrections, so I was slightly late. Be here at